instructions to everyone. We would be starting with the session soon, but prior to that, please check that your sound system is on mute and you have not switched on your video. Okay? Thank you.
Aparna madam.
Yes. Good morning, sir. Good morning, ma'am.
Namaste, Sumitra ji. Again
Sumitra
meeting.
ma'am, namaste.
So
Yes,
go ahead. ahead.
Okay.
Yeah.
Netal.
Nitin,
So should I begin, sir? A very good morning to everyone. I, Nathan Agrawal, welcome you all for the inaugural session of one-day online capacity building workshop on research methodology organized by Marathwada Legal and General Education Societies, Manikchand Pahade Law College, Aurangabad, IQAC Department. A very warm welcome to our chief guest, Honorable Professor Dr. T.V. Subbarao, sir, Professor Emeritus, Vivekanand Institute of Professional Studies, New Delhi, principal, teachers, and all participants. I request our college principal, Dr. C.M. Rao, sir, to give the welcome address. Over to you, sir.
On behalf of the management, staff, and students, I warmly welcome Professor T.V. Subbarao, the ocean of knowledge in the field of research methodology, and the other resource persons, Professor Sumitra, Vasundhara Madam, Akash, and Professor Mansingh for this wonderful August mist, for wonderful deliberations, for the understanding the subject in detail for the purpose of your future career. So there are 343 participants all over India who joined in this particular webinar. Really, I hope that you are going to enjoy this particular academic endeavor that is taken up by our IQAC coordinator Aparna Kottapalle and other colleagues who joined with her for making this program a wonderful deliberations among the participants, also students. And at the same time, I would like to bring to the participants, this college was established in 1956, affiliated to Osmania University. Then it was affiliated to Dr. Babasaheb Ambedkar Marathwada University. Recently, on August 1st, we celebrated 65th Foundation Day. And this is run by a management committed for its goal, only rendering excellent legal education for the downtrodden in rural areas. There are 1,400 students who are pursuing LLB in this institution. There are 220 students who are pursuing LLM, and the remaining 400 are pursuing these particular diploma courses, tax laws, and other things. So out of these particular courses, there are 581 women are pursuing the law, legal education course. So I would like to mention further that this was accredited by NAC in the first cycle with B+, in the second cycle with A, in the third cycle B+. This is because of the continuous help from the management, staff, and students. The faculty is making their efforts to achieve their goals to make this institution one among the top law colleges in India. And at the same time, whatever the ideas that are brought by the staff are going to be accepted by the management, and this program is one among them. And at the same time, I would like to brought your knowledge that this is the institution. In 2010, it is 101 among the 100, and last 5 years or 6 years, it reaches first, 6th, 7th, 8th, 9th, 15th, 16th, 21, 27, 32, 37. These are the ranks that are made by India Today, Outlook, Careers Magazine, Competition Success Review, all these particular various magazines who conducted survey makes this institution wonderful in this institution. And alumni of this college is from Supreme Court to the local court. Supreme Court judges are there, and there are High Court judges from this court and Andhra Pradesh also. So with this brief introduction of this college, I welcome once again Professor T.V. Subbarao and other guests for this wonderful discourse on the particular subject of building capacity on the research methodology. Thank you, one and all.
Thank you, sir. We all have
Shall I
gathered-
start? Netal Agarwal?
No, sir, just a second. I would like to request Aparna Kottapalle ma'am to give a brief of today's event, like a one-day workshop.
Honorable Professor Subbarao sir, Sumitra ma'am, respected principal sir, all the faculty members of this institution, Vice Principal Shri More sir, and dear participants. It gives me immense pleasure to introduce this particular workshop, which is being organized online through IQAC. This online capacity building workshop is organized by IQAC for certain objectives to be achieved. And in listing the objectives, basically creating the interest among students as well as faculty about the research methods. As we know that unless and until we adopt the scientific methods for continuing the research, success is impossible. And hence providing orientation about the same, skill enhancement is essential. And hence we are grateful for all, including our today's inaugurator, Honorable Professor Subbarao sir, who all are stalwarts actually. So during this one-day online workshop, we have got different sessions. During first session, respected Sumitra ma'am is there with us, and she would be delivering her content. She would be enlightening us on the doctrinal research. In second session, immediately Dr. Vasundhara Kamath ma'am would be there, and she would be delivering on non-doctrinal research, and especially she would be linking it with the legal research, socio-legal and legal research, importance of that. Then there would be half an hour's break. Okay, by 12:30 we would be gathering again, and Dr. Akash Singh would be talking about the jurimetrics and other legal research methods in which we can take the help of online resources, okay, open access, etc. During last session, Dr. Jit Singh Man sir, from Delhi National Law School, he would be enlightening all of us on writing of research projects, proposals, as well as reports. So I hope this workshop would be really capacity build. It would be really capacity building workshop for all of us. I wish you all the best for your research endeavors in future. And before ending up my small speech, I would request everyone that at the end session, a feedback link would be shared to you. Please do not forget to give your feedback, valuable feedback, on the basis of which we would be able to improve ourselves in future events. Thank you so much. Thank you, everyone. Over to you, Neetal.
Thank you, ma'am. We feel honored that our workshop is graced by Professor Dr. T.V. Subbarao sir. Before we march ahead, I would like to give a brief introduction about our today's guest. Sir, with your permission, if I give the introduction.
Will you please be rather very brief?
Yeah, sir, for sure.
Very brief. I am a professor emeritus whips over. What more people want?
Sir, there are participants who are really willing to know about you. So.
No, they will know by my rather lecture whether it is good, bad, or ugly.
No, sir,
The reason
definitely
is
it
that
would be the best.
should not consume much time on these formalities. Okay?
Okay, sir. Just a brief introduction for sure.
Sir.
Professor T.V. Subbarao sir is presently working as Professor Emeritus at VIPS Delhi. He started his career in law in 1978. Trained and reputed institutes and country, sir has a specialized knowledge in constitutional law, international law, human rights, family law, cybercrimes. Two key areas of women and law and research methodology continue to be his area of interest. Sir is known for his contribution to development of curriculum in law in the capacity of chairman and member of board of studies in various universities across the countries. Sir has worked hard in implementing the component of clinical legal education in the curriculum. As a researcher, he undertook the task of judging the justices. He is a writer, and his zeal for academics is evident through his work and publication. He has good number of publications to his credit, 2 books, edited 6, co-authored 1, 25 articles, and 23 papers. His works are often quoted. He has organized 41 conferences, seminars, workshops, and much more. He was a resource person, trainer in 168 seminars. Gladly, we are also one of them to hear him. He has successfully guided even PhDs thus far. He visited the countries US, China, Nepal, and Thailand. His mission has been to strive for knowledge-based society through imparting appropriate academic and professional skills among the students in the field of law and to promote among them all competent and competitive performance. We are so blessed to have you, sir, and to have this opportunity to get some knowledge from you. Now, without taking any further time, I would like to ask sir to share his findings and insights about the overview of research methodology. Over to you, sir.
Can I start?
Yes, sir, definitely.
Am I audible and visible clearly?
Yes, sir, you are completely visible.
No problem to anybody?
No, sir,
Yes.
no, not at all.
Yes, let us start.
Yes.
At the outset, let me thank the charioteers of this program. A person, gentleman to the core, with affable manners, and a person with very good knowledge and grip over the subjects of law, Professor Dr. C.M. Rao, Principal, his able team, Professor S.N. More, Dr. Aparna Kottapalli, and our wonderful anchor who will not listen to us, Netal Agarwal, and other authorities of Manik Chand, Pahade Law College. I also thank those colleagues of mine who are present to share their views, Professor Dr. Sumitra ji, Professor Vasundhara ji, and Dr. Mand. I wish that your institution should soon become an autonomous one and an autonomous university as well. The reason is that after some time, maybe we may not be there on the earth at that time, all the affiliated colleges will turn into deemed universities. I expect that you will live up to the mark, go further in your accreditation, for which you are all eligible. Now, let us start the subject. Dr. C.M. Rao, when he contacted me, I requested him, what is the topic? He said, general overview of research methodology. I wonder, I may take 1 week. The program that was being rather informed to you by Dr. Aparna Kottapalli may not stand if I start talking about research methodology, leave alone details of research methodology. So what I would do is a brief introduction about research. He was also talking about doctoral research and all those things. I will touch upon it, and I will be touching upon scientific method. While doing so, we will be able to cover comprehensively certain things related to the research which are very, very important. My friends, listen very carefully. All progress is born of inquiry, not enquiry. Now, E is not there. That is subsequent addition to the dictionary. All progress is born of inquiry. Doubt is often better than overconfidence. For it leads to inquiry, and inquiry leads to invention. These were the words of Hudson. My friends, I tell you very frankly, the people belonging to the other disciplines, they will not accept that we are researchers. The reason is that we are not bothered much about the technicalities or of the review of the literature. All these things are absent. They say that we are not systematic. What we are producing is not rather a scientific study of anything. What I tell you, my friends, unlike other disciplines, in other disciplines, they do their PhD, they do their research for some purpose, some people, others won't take up that one. But with reference to the discipline of law, all law persons involve themselves in legal research every day as an advocate, as a legal executive, as a judge, or as a scholar, or even as a law student at LLM level. All are involved somehow or other in the legal research. But I do concede how systematic their briefs are. Of course, it is a matter of concern for us. You take Supreme Court Judge Dr. D.Y. Chandrachud. Did you see his judgments? Each judgment is a sort of thesis or a dissertation. The distinction between dissertation and thesis is very thin. It is a degree of rather standard rather than of the content. Okay, you go to an advocate, he starts researching about your case. You will go and sleep happily once you hand over the case to the advocate, but the advocate has to work on that. The tension is his tension. Legal executive, when you go to the legal firms and start working with them, it may be monotonous, but every day you are asked to make a research. And your postgraduate degree is almost a research activity. In fact, PhD is defined in some dictionaries that it is a postgraduate study. Okay. Then, so as law persons, we should be proud. We will be doing research, whether they recognize it or not. That is a different issue. We will say, we will see why we are not recognized and we try to rectify it. Now, my friends, research is primarily to see what everybody else has seen. Everybody will be seeing. So research is to see what everybody else has seen and to think. That is important. And to think what nobody else has thought. Before and after Newton, many people must have sat under the tree of apple. And even for Newton, several times apple must have fallen on his head. But he started thinking one day about the gravitational things. So, take Keshavananda Bharati versus State of Kerala, year 1973, Supreme Court, page number 1461. Prior to that, there was Shankari Prasad Singh's case, Sajjan Singh's case, wherein the doubts, they have expressed two doubts, and as a matter of reference, you can see even basic structure, and it was vehemently argued in I.C. Gorakhnath versus State of Punjab by the council for the government about the basic structure. But the judge said that is not necessary because it can be decided on narrower ground. So prior to that, there was occasion, but still it is in Keshavananda Bharati's case, wherein the basic structure theory is formalized, even though definition is not given. Even now we cannot with certainty define what is basic structure. Each case has to be tested on its own. And then cases are going on, especially after Maneka Gandhi versus Union of India, year 1978, Supreme Court, page 497. 597, I think. The concept of life, personal liberty and procedure established by law under Article 21 is liberalized. But still, they did not use the expression transformative constitutionalism. Transformative constitutionalism was rather used in two cases, Joseph Shame and Navate Singh's cases. And again, Dr. D.Y. Chandrach is one of the authors of that. They have imported from African scholars' exposition, made transformative constitutionalism as a strategy for interpreting the Constitution. Prior to that, till then, how many years elapsed after adoption of the Constitution? But they have invented, they have brought, even though it is from African Constitution, not their invention as such. Recently, in Lieutenant Colonel Natasha's case, you must have seen paragraph F, you read it, my friends, how Dr. D.Y. Chandrachud has given the conceptual framework of indirect discrimination. He has quoted from almost many countries, England, America, Africa, Canada, like that. Indirect discrimination, that itself is a piece of very great research, I tell you. Some of you who are interested, who are in, rather want to pursue PhD, may think of that. That is wonderful decision, even though it is division bench decision. 2 judges only. My friends, according to Article 145, Class 3, there shall be at least 5 judges in the cases leading to the interpretation of the Constitution. You must be knowing it. So, what I am saying is that research is to see what everybody else has seen and to think what nobody else has thought. That is wonderful research. And research is for what? It is a search for knowledge. There are aims of research you can list out for the purpose of examination. I am not going to touch upon it because it will take a lot of time. I may touch upon classification of research because even your mentor Dr. C.M. Rao was asking about it. And then research in general is a search for knowledge. Is it mere knowledge or beyond that? Samyak Vikshanam, Jnanam Samyak Vikshanam. With equanimity and discernment, you will have to view for the knowledge. It is not mere information. My friends, at the first stage, information may lead to knowledge. Knowledge is not power as such. Knowledge coupled with wisdom is power. And etymologically, you know that research is to search, to go around in circle. These are all the things which you will find in your books. It is an active, diligent, systematic process. The underscoring expression is systematic process of inquiry in order to discover or interpret or revise the facts already in existence. So it is an intensive study. You require patience for that. Okay, systematic study directed towards more complete scientific knowledge, I say. Scientific knowledge doesn't mean pure sciences. I will come to that when I discuss about rather scientific method. My friends, now you take very old definition. You take very old definition of research. Encyclopedia Britannica. Because we do not have time to discuss about other definitions, I am only supposed to give overview. I am talking about this. Research means the act of searching into a matter closely and carefully. Closely and carefully. Inquiry directed to the discovery of truth. It is not finding the truth, it is discovery of truth. And in particular, scientific investigation. Remember all these expressions, my friends, I will be using them quite frequently. Are the principles and facts of any subject. They did not say chemistry, physics, biology like that. Of any subject based upon original first-hand study of authorities or experiment. So it is aimed at discovery of truth. As we know, truth is eternal value. Scientific method is a value by itself. Okay. Actually, when you say scientific method, automatically ethics and values are taken care of. Brahmam Satyam. Truth is only one. Ekam Satyam Vipra Bahudha Vidhayate. It is stated, described by the learned people differently. When I was reading this transformative constitutionalism concept, why did not they take into account living constitutionalism? It is different from originalist, that is different issue. Living constitutionalism just meets that point. But they went to the African scholars' exposition of transformative constitutionalism. So viewing the things differently. One of the fundamental duties, as you know, under Article 51A, my friends, I think H, class H, it is to develop scientific temper. Scientific temper is required not only for law, even for other subjects, not only for physics, chemistry, etc. It is for us also. Okay. There should be a method in madness, that is what we say. Why can't there be a method in research which we are doing every day? Only when there is a method, it would be systematic. Only when it is systematic, you call it as scientific method. Okay. Now, before going to give you one aspect of thinking or reflective thinking, let me tell about the kinds of research. It is very fundamental, my friends. You cannot give an exhaustive list of the kinds of research. The research works are vividly classified. Then, not in the beginning, after they have done the research, they are classified based upon their nature, purpose, and methods that are used. Doctrinal, empirical research. Whether law is fit for empirical research or not, I will be discussing when I discuss about scientific method. Doctrinal and empirical research, descriptive and analytical research, fundamental applied research, qualitative and quantitative research, field research and laboratory research, historical research, exploratory research, or diagnostic research. After stating all these things, I am going to add one more point, that this list is not exhaustive. The classification is also not exclusive, but overlapping. Okay. One of my students brought one day research thesis. She said, mine is doctrinal, descriptive, qualitative, and analytical research. All the names she has given. So, but there is a specific purpose for each one. Don't bother about that name. For example, he was asking for doctrinal research. Doctrinal research is related to developing the new or modifying or testing the existing concepts. Are you doing it? Understand? Doctrinal research is related to developing new concept. Are you developing new concept? How can you call your work when you are analyzing simply? Yours is analytical research, not a doctrinal research. New idea should be there. Or modifying or testing the existing ideas, abstract ideas or theories. Okay. On the other hand, empirical research is based upon the data collected as a sequel of our experience with our senses and all these things that I will discuss a bit later. Descriptive research is description of the existing things. That is also a research. And analytical research involves a critical appraisal of the given information or material. It may be systematic study. And it may be applied even for quantitative data, my friends. So, similarly, fundamental research or pure research, they are not bothered about the world. Research is research sake. That's all right. Why should you bother about the society and all these things? This is another kind, applied research, experimental research, or all these things. I just only mentioned to you in order to rather take you to other important things. So, research shall go systematically, that is scientifically. How do we go about it? It involves theories, deductive reasoning and inductive reasoning, empiricism, hypothesis, propositions and concepts, all these things. One or two lines we may think about certain aspects. Thinking process is there. How do you think? Normally, what we do in our life repeatedly becomes our habit. Every person will have some habits because he routinely is doing. Child is there. You don't require special training for the child to take the milk. Immediately it starts. So it becomes rather a habit, and your thinking also is conditioned by it, and it is called routine thinking activity. It is a routine thinking activity. For research purpose, what you require is reflective thinking. You require reflective thinking, which we need for the research. Okay, even it can be stated in our own language, Chintana Prakriya, it is called reflective thinking. And then Vichara, inquiring about it, inquisitiveness, quest for knowledge. Not that Arjuna was hearing always Lord Krishna. When he has made Astra Sannyasa, renouncing the Astras and Shastras, he did not consult Lord Krishna. That is why for some time he teased him. Lord Krishna teased Arjuna. Okay. What he got now? Vishada, Arjuna Vishada Yoga. That was the first point of Bhagavad Gita. So when you are confused or having that vichara, what is this, what I am doing? For what? You will have that Chintana Prakriya, and that was ignited by Lord Krishna, and they went for finding the truth and ultimate truth. That both are different, my friends. And then for research, one more quality that is required is that you should go into long time memory, not short time memory. If you book a ticket in your flight, you will remember it for the time being. Afterwards, you will forget about it. But for research, you will have to repeat it so that it will be there, stored in your long time, rather term memory. My friends, if you are interested, Devi and Kennedy model of research is there. Reflective thought process. You can think about it. Why your PhD is called Doctor of Philosophy? So you have entered into realm of philosophy after doing your research work. From realm of science, you are going to realm of philosophy. Doctorate in science, they are not saying, my friend, my dear friends. So in realm of science, these initial things are there. Experiences coming out of your research. Theories, inferences, facts, hypotheses. And then you will enter into finding the experimental truth, and then ultimate truth. And this is the process that we will have to think of. Chintana, Shodhana, Vijnana Samshodhana, specialized knowledge. Mind it, my friends. The ultimate object or objectives rather of research is to find the solution, and in the process, it is finding the truth. But remember always, my friends, one has to go for ultimate truth. I am not going into the philosophy and other things now. Ultimate truth. Truth is like number of stations. You are in a train. You are reaching the last station. Ultimate truth. Meanwhile, there are several stations. Each are rather true. It is a train of truths. And ultimately, you will reach the ultimate truth. One has to reach ultimate truth, and one should not be satisfied with reaching one station. Truth perceived is only one of the stations in the train of knowledge. You have train of knowledge. In that train of knowledge, you will have to reach the ultimate truth. Not whatever steps we are taking. I used to tell when I was rather asked to talk on research methodology in my own this one, I told them PhD is not a peroration or a conclusion of your research. Actually, your research process begins with that. Okay, Sir Isaac Newton once stated, I am a curious child with catering steps on a vast series of knowledge. I am just filling my little pockets by collecting pebbles. And therefrom, the ocean of knowledge is there. I am only collecting the pebbles. But he explained also, gravity explains the motion of the planets, but it cannot explain who set the planets into motion. Understand? So, next one is Thomas Gray. They're all scientists. I am giving specifically scientists one. Dark fathomed areas in the oceans bear the genes of the knowledge. Okay. Dalton is there. He said originally, atom is indivisible. We are exploding the atoms itself. Now, people, scientists know neutrons, electrons, protons, and it is an accomplished one. Whether it is destroying the people or protecting the people, that is different issue. That is why Alexander Pope, he said, drink deep, Taste not the billions spring. Little knowledge is always a dangerous thing, my friends. Okay, always question what, when, who, and where. Suppose you put these 4 questions. What, when, who, where. You will get a description of the phenomenon. Then you start questioning why that particular phenomenon happened. Phenomenon happened. How it has happened. Then next stage, that is analysis you make. Then evaluation. What if that particular phenomenon has happened? What if? So what? And then what is the next thing that is predictable? You will go for that angle. So inquisitiveness and interrogatives are always better for scientific study of anything. Now I will take a small deviation here in order to explain to you what is deductive thinking. There is already established knowledge. From that you deduce certain things. Using deductive reasoning, one starts with a given theory as the basis for which he develops hypothesis. Hypothesis is plural, hypothesis is singular. And then confirm these with specific data that you may collect. Okay, using observation or experiment, and we do not agree totally that only empiricism is a valid one. Inductive reasoning, on the other hand, one starts with specific observation and develops a general pattern and tentative hypothesis. Whether true or not, you should prove it. So, while making inductive thinking, one introduces his own philosophy after analyzing the data or after analyzing the facts available. Okay, then what is a proposition? Proposition is a statement, concern. It establishes relationship between the concepts as well. Okay, it asserts universal connection and logical linkage between the concepts. They are abstractions. Smoking is injurious to health. You say a proposition you have made. Hypothesis, my dear friends, it is only an overview. That is why I am giving in 3 or 4 lines. Hypothesis is a tentative generalization, the veracity of which may be proved or disproved by analysis of the data. Okay, may be proved or disproved, but it is a tentative generalization establishing relationship between 2 or more variables. Okay, that it is y is equal to fx form. If this happens, this will happen. If this is not happening, this is not going to happen. So in all these things, cause and effect model. If it is not cause and effect model, what you will have to think is that yours is only a research statement. Often our people are confused between research statements. They are not bad, but it is only a statement. It is not showing causal relationship, not casual, causal relationship. So, if and then, because it is happening, if salary is increased by 10%, there will be a double production in the factory. This is the cause, that is the effect. So cause and effect model always it should be. And now, can you apply scientific method to law or legal research? Let us see. What is scientific method? Go systematically. Systematic pursuit of knowledge. is science, my friends. There is no shortcut to truth, no way to gain knowledge of the universe except through the gateway of scientific method. Karl Pearson, he has stated. Science guards against untested assumptions, fanatic or faddist beliefs about the world we live in. Science proceeds on the premise that it is better to know than not knowing anything. That is, knowledge is better than ignorance, I told you in the beginning. Ignorance is bliss, is not applicable to this research. Science is not confined, as I am repeating, to the pure sciences, my friends. Science goes with the method, not with the material. Write down that statement. Science goes with the method, not with the material. Never. It is not what is accomplished, but how it is accomplished. I will give you the observations made by two scientists, famous scientists. Thomas Huxley stated that science is a trained and organized common sense. He did not say any specific subject. He said science is a trained and organized common sense. Law people have common sense in abundance. Only thing is that he should be trained and organized. Okay. Is it not? When compared to others, law people have abundance, common sense. And then Albert Einstein, that is another thing, stated that the whole science is nothing more than a refinement of everyday thinking. What did he say? The whole science is nothing more than a refinement of everyday thinking. Everybody thinks. Refine that thinking. It is a science, he said. So, science is a systematic accumulation of knowledge, good and bad, has mentioned that. Lastrucci also mentioned the same. I am not rather going to repeat their definitions. So, there is misunderstanding about this particular aspect. What is that misunderstanding? Now we will look into whether science is confined only to empirical study. Kerlinger pointed out that scientific research is a systematic, controlled, we have no objection, empirical and critical investigation. He emphasized on the word empirical. What do you mean by that? Okay. Theoderson, he also stated scientific method is building a body of knowledge, scientific knowledge, through observation only. If you are not able to observe, so that is not a research for him. Thus, anything based on speculation or a hunch or a mere guesswork cannot be treated as scientific inquiry. Can you accept that? Auguste Comte, in the year, I think, 19th century, 1848 or something like that, proposed what is known as empiricism or positivism. He stated that social phenomenon cannot be studied based upon logic, throwaway logic. So our tarka also, leave it. Our theological principles, our metaphysical theories, we are not bothered. But studied in society based on social relations derived from sensory experience. Whatever you see, whatever you hear, whatever you talk. For example, poverty is a dominant force in the society. Discrimination of women directly relates to lack of property rights. So these are the things which you can find through your sensory studies. So now there appears to be a reason, okay. But can we say always empirical study is only a research, not other studies, not normative, not historical or deductive or whatever it may be, unless you see, unless you perceive. Jocularly, I was telling, if you accept Auguste Comte's one, the whole circumstantial evidence also goes. Now, leave it. That was in a light version I said. It is also based upon some specific evidence. Links should be there. If one link is removed, automatically the chain is snapped. Now, empirical research refers to the observation of facts and interaction with the people. It is scientific knowledge is based upon verifiable facts. Agreed? If you take historical research, my friends, I tell you, originally, historical research was the only research. It was considered to be the research. Other research was not research. So research based upon logic, he has studied, he said no. Biographical research, how can you say no for that? Always statistics is not possible. Geometric limitations are there. If time is there, I will be touching on that point also. There are other factors like symbolic interactionism, phenomenology, ethnomethodology. All these things are proved to be research systematically made. How can you ignore it? My friends, I tell you, symbols are the original communicative instruments. Only symbols, no language. Language afterwards it has come. Who has given the name that it is computer, this is wall, that is hill, like that. Somebody has given, that is human being has given. That means it is subjective, not objective as such. All the things based upon language, how do you explain? How based upon symbols, how do you explain? So, it shows very clearly symbolic interactionism. I think it was conceived by George Herbert Mead and Charles Horton Cooley. Not merely qualitative or quantitative. My friends, I tell you, language and symbols, they gave us the meaning and we base it on this particular thing. And you cannot rather simply say only through empirical study. It was out rather afterwards, after Auguste Comte, people started questioning the veracity of it. If you strictly apply the Marxian philosophy, a wonderful philosophy that is, may also not fit clearly into empirical study. If it were to be so, communism must have come in France or England. But can you throw out the Marxian theory? A wonderful theory it is. So the post-empiricists believe that scientific method is not the only confined to empiricism to arrive at truth. They say that the irreducible minimum may be systematic. Once it is systematic, you cannot throw out logic, you cannot throw out tarka, you cannot throw out mimamsa type of interpretation. When you talk about geometrics, my friends, it is application of quantitative methods and often especially probability and statistics to law, used primarily by academia to mean a strictly empirical approach to the geometrics. In a country like India, when you apply geometrics for a shorter tenure of the judges, will you be successful? I tell you, geometric analysis, I rather prefer Justice Koka Subbarao was there. In majority of the cases, he favored state. So can you throw away his contribution otherwise, wherein he was rather against certain things perpetrated by the state? What happened to Devadasan's case? What happened to I.C. Golaknath's case? What happened to Makkan Singh's case? His dissents have become majority subsequently. Okay? In privacy case, he was quoted and relied upon. So when you completely base your things on geometrics, which was rather, the term was first coined in 1949, but Loewinger, a wonderful. You know about econometrics, huh? A subject and discipline that is there in various universities. Statistics for the use of economic analysis. Geometrics, jurist. Metrics, statistics. If this is like econometrics, a quantitative analysis of judicial behavior. There is a basic problem in such things. But in America, plenty of literature was there with very good results with regard to geometrics. But in India, it is a dismal. Only very few are there. Very few. Okay? And now, take 4 concentric circles. I am now went back to scientific method. Okay? Science is there in the middle. What is the goal? Goal is knowledge. What is the method adopted? Systematic. It is systematic. So, science is a systematic accumulation of knowledge. That is the statement. Whatever may be the subject, including law, whether law can be made scientifically or not, I will tell you. So, science is an approach. It is an approach. That means it will give us a frame. In that frame, we will test it. And then the result is that it will formulate a theory. Science is always cumulative, my friends. Already this knowledge is there. Next you add to that. Next research you add to that. Till we reach ultimate truth, it will go on. So science is always cumulative. It has a transmissibility. Transmissibility means no geographical or political systems can bar it. For example, you take oxygen, how it is produced. KMnO4 plus MnO2 plus H2O leads to the oxygen, we said. Wonderful. It is produced like that, whether it is in India, Africa, or America, anywhere same results. So also here we must have the same results. Can you apply this to legal research? Urbanization leads to criminality. Yes, it is a fact in India, in other countries as well. Transmissibility is there, but only percentage may vary. And then there is what is known as replicability and verifiability. Replicability and verifiability. You can repeat it any number of times, same results will come. Similarly, verify it number of times, same results will come. More than that, science is rather a thing that establishes causal relationship. As I have told you with regard to hypothesis, it provides causal relationship between two or more variables. If then hypothesis is proved or disproved, that is different issue. Causal relationship was struck down. No, this is not proved. This is not a valid one. And then scientific method requires parsimonious effect. What do you mean by parsimonious effect? A larger phenomenon can be stated in few words. A square plus B square is rather plus 2AB. We have noted A plus B whole square. We have shown A plus B whole square. If you want to prove it, draw a right angular triangle, rather measure one square and hypotenuse and other squares on other two sides, then only you will be able to say. Lot of things in simple formula, A plus B whole square, they said. Parsimonious effect. Take legal research. Unless it is 400 pages, your guide also will not accept. No, you will have to add something more. It is with only few pages. Geometric analysis can be done even in 50 or 60 pages. Now judgments are not more. Take one of the judges now on the bench, make a geometric analysis. So my friends, science always gives objectivity, verifiability, replicability, generality, predictability, and it should be systematic. Now the question is, can you apply scientific method to legal research? Simple point, my friends, I tell you. Law can never be, for that matter, any social science can never be E is equal to MC square. It is not at all possible. 100% is not possible. Even with regard to scientific investigations, they are not able to give 100% assurances. That is different issue. But law can never be E is equal to MC square. But by systematic approach, errors may be minimized and near perfection may be achieved. We do not have time to discuss those things. More the sample, less the errors. Test it. We are in the habit of taking 5 judges a sample. Not at all valid, my friends. Error is accepted only up to 15% or 10%, not more than that. If you take 5 judges, 2 judges express one opinion, then it will become 20%. Smaller the group, more the problems. So what they say is more the sample, less the deviations. That is different issue. When you go for sampling technique, you can know that. Why it is so? Why you cannot achieve perfection with regard to legal research? Human behavior changes too much from one period to the next period to permit scientific exact predictions. Yesterday, I was discussing with our professor, R.V. Rao. I was telling him how human behavior changes. Today, I give you a question and an answer sheet. We will ask the teacher to verify it. It is not objective type, but essay questions. He gives awards marks neutrally. Forget about it for some time. It will be in the short time memory. Give him after 1 year the same answer sheet. Will he give the same marks? Not only that, even day to day, there will be a change. Human behavior changes, that is human being. That is the characteristic of a human being. It changes too much from one period to the next period to permit any scientific and exact predictions. And then artificial instruments and other things won't do good. Human behavior is too elusive. Same person, in the same situation, acts differently. One more problem is that you are studying human behavior. Who are studying? It is studied by other human beings. This human being has errors. That human being has errors. If it is put together, the errors will be more. And sometimes the people have the habit of deliberately upsetting the predictions. How? I tell you. Total error, suppose you take. There are two possibilities mainly with regard to errors. Random sampling error, systemic errors will be there. Random sampling error will be there. Systemic error will be there. How random sampling errors are? It is best. At random, no personal attitude is there. My friends, you take sample from 1,000. First sample you have taken. Next sample when you are taking, you are not taking it from 1,000, you are taking from 999. You say, so in such cases, we will supplement it, replace. At any given point of time, 1,000 will be there. Suppose you have replaced with one more item, that item is selected. Did you select it from 1,000? It is a replaced item. So random sampling error otherwise may also occur. It may be it may not be random also. Systemic errors are there. Certain errors are committed by the administrator of the research itself. For example, data process error, that is there, scientifically proved diddling. Diddling you must have heard. Some time back in our state, billing and collection of money, rather billing was given to chartered accountants and they have employed their people. They have gone there. They enter into the computer, process it. Just before process, when it is printed, going for print, they will remove one figure. 1 lakh is there. Remove 1 0. It will become 10,000. And afterwards, again 1 lakh is restored. You cannot find. Consumption was more, revenue was less. Then they had to make very great research to find that there is a diddling. Every bank has diddling, my friends. If you 10 rupees is taken from your account, do you know that? And suppose it is taken from millions of people, how many millions of rupees they will be collecting? Sample selection is there. When you want to go for random sampling, probability or non-probability sampling is there. Non-probability sampling also is required sometimes. Cluster sampling, area sampling, stratified sampling. So errors are bound to be rather there. They are bound to be there. Nobody can say totally we have overcome this one, not possible. But errors to some extent only, they are acceptable. And take interviewer's error. You are not all knowledgeable. You may commit error. Interviewer cheating also is there. You will sit in your hostel and make up the statistics as if reasonable, prudent person. I am a reasonable, prudent person. I can fill 10 forms to get the data. And then respondent errors are there. Respondent errors. Natal Agarwal, can you give me a few more minutes? Natal Agarwal, do you give me few more minutes? I will complete.
Yes, sir.
Sir, go ahead.
How much time I have?
It's 5 minutes.
So, respondent error is there. First thing is, suppose the questionnaire is sent to me. I will not give response. If at all response is given, I will ask my research student. So is it a true sample, representative sample? I am not giving the answer. I am not responding even. If you send 400, you will get 50 responses. Response error is there. Response bias also is there. How the response bias happens? Deliberate falsification. You pose yourself as the greatest professor under the sky. You are an ordinary teacher. Always you want to uplift your data. Okay. Then sometimes innocent misrepresentation also may be there. Unconscious misrepresentation. You do not know. You won't say that I do not know. You will fill some or other. Some statistics you give. Acquiescence bias will be there. Extremity bias will be there. And then auspicious bias will be there. Social desirability bias will be there. Generally, you won't rather accept encounters. Article 21 per se. Police encounters are per se not valid. Number of cases are there. Suppose a particular event has happened, as in Andhra Pradesh, immediately the people went on Bandh and Dharna, asked the police to make an encounter. And then, generally, if you are asked objective type question, you will say, I am against encounter. But certain circumstances, you say yes. And social desirability. He must have taken lakhs and lakhs of rupees as rather varakatna, dowry. But you say dowry is not correct. Social desirability. He will fill up that column. So, having all these things in mind, can you say we should not have any research because human beings are malleable? That is not correct. Even science is not 100%. As I have given you example of Dalton, and I have given examples of even recent vaccination you can take. 100% foolproof is not possible. That is number one. Number two, they have not reached the ultimate truth. Ultimate truth is the only thing that is constant. This is our only intermittent or intermediary stations. My friends, always there is a confusion. Theory and fact, they are different. Wonderful analysis has been made in Good and Bad book. There is a misconception that science deals only with the facts and not concerned with the theory. Theory is always speculation, they say. That is not true. A fact is regarded as empirically verifiable observation. It is a fact you can see. You can say. And theory refers to relationship between the facts. If two facts are there, you establish a relationship. So, how can you say that theory and fact, they are not interrelated? Okay. Facts are productive of theory. Okay. Facts initiate theory actually. They lead to formulation of the existing theory or reformulation of the existing theory or modification of the theory. All these things are possible. Whereas theory is the major orientation of science by providing parameters of data that are required. Based upon the pre-existing theory only, you formulate your problem, you formulate your hypothesis, and you will proceed to collect the information. So, facts will lead to the theory, theory will lead to the facts. The ultimate thing is to theorize like that. So, this is the background of research. In 2 minutes, I will complete this one. Research process is there. Now I have given you introduction about research. Basic orientation relating to research. Now, research process. How do you go about it? The first thing is formulate a research problem. Formulate a research problem. What we will do? Directly we will go to the proposed supervisor, even though signature is yet to be given, and ask him, sir, what problem you want me to do? Give me a problem, I will do it. I did the same thing, my friends. I threw the introductory letter on the table of my professor. He did not throw me out. He was thorough gentleman. Very great teacher I have seen under the sky. Very great teacher. He looked at me and simply stated that I am very happy that you have keen interest in doing the research at very young age. At that time, mine was the only research as a teacher. That is why I could get early rather positions. That is different issue. Leave that history, biography is not necessary now. Then when I asked him, sir, please give with the research topic, any topic under the constitution, he go. He said, what is the definition of research problem? Simply he has asked. Then memorizing only or after at that time. Research problem is any difficulty faced by the researcher for which he wants to find a solution or she wants to find a solution. Repeat it, he said. I repeated it. It is any difficulty faced by researcher, not by the guide, not by somebody else for which you find a solution. You will have to have that intrinsic motivation to do the work. That is why the problem should be yours. It is any difficulty faced by the researcher for which you want to find a solution. That is the first thing. The guiding principles, how to formulate a research problem, that is a topic by itself, my friends. Steps are there as to how to form. Choose a broad topic, then narrow down all these things. Okay. The next step is that is generally ignored by the law people is that reviewing of the existing literature. Reviewing of the existing literature. If you go to other social sciences or to the education department, if you refer to their thesis, one big chapter, not a small chapter, very big chapter will be for reviewing the existing literature. Why we are ignoring it? Not that we don't have the literature. We have the literature, but we ignore. That is our wonderful idea. And then, if you go to the guide also, what we will say? In the introduction, One of the components, minor components of 1 or 1.5 pages, review of the literature. For reviewing the literature, it takes as if you are writing a dissertation. In the loopholes, interstices that are left out, the things that are answered, not answered, you are going to answer. That is why review of the existing literature is there. That itself is a sort of a lecture. How do you review the literature? How many steps are there in that? And then after reviewing the literature, now you know what to do, why you should do. When you put the question why, you will get objectives. Then formulate the hypothesis in cause and effect model. You may also give, for your satisfaction, research questions. Questions will not establish causal relations. Research questions also can be mentioned, but formulation of hypothesis is a vital part of it. Then, in some universities, they insist upon addendum of procedure, how you are going to do your research. Take a rough, you need not submit to anybody. Write down what is that I am going to do. Addendum of procedure. And a formulated in a particular manner, a thing that is suitable is research design. If you want to construct a house, you require a blueprint. That blueprint is research design. You arrange brick by brick very carefully. And after the house is constructed, you will be very happy to see. Similarly, research design, starting from blueprint, and then at every stage, you are bothered about the construction of your house. And meanwhile, some fellow will come and say, no, in northeastern side, there should be one particular thing. Okay, the door shall be there. Then you modify it. So research design, except in for exploratory and all these things, may permit bit modifications as well. There are classifications of research design, a vital one. There are 7 questions that are mentioned in Paul Young book. You just answer those 7 questions. Your research design is over. And then, my friends, after research design is over, collection of data, how do you go about it? Okay, collection of data. It takes a lot of time. Analysis of data, next one. Data is analyzed, that is different. Then interpretation of data. Interpret the data. And then report writing, several types are there. We say conclusions and suggestions and conclusions. Okay, findings are different from conclusions, my friends. Findings are different from conclusions. Don't be confused. Okay. So with this, I think that I have given you introductory inputs for your research or research methodology workshop, whatever it may be, and anything which you want further. If you give me time, I have no objection to cover. But the thing is that I think I have exceeded my time, and it is up to now Dr. C.M. Rao. Thank you very much, sir, once again to all the participants and all the people that are assembled here. Thank you.
Thank you so much, sir. It was a great session, and all of us have definitely taken up lots of learnings and information. Concluding our today's informative session, I would like to propose vote of thanks and take this opportunity to thank our guest of honor, Dr. Professor T.V. Subbarao, sir, for making us connect to the topic and enhance our understanding on the same. Thank you, sir, for giving us the insights. Further, I would like to thank Principal C.M. Rao sir, Vice Principal Sri Kishan More sir for the efforts of organizing this workshop and providing such platform for us to learn. Sincere thanks to IQAC Coordinator Aparna Kotapalle ma'am for her dedication for students' welfare and continuous encouragement. I would like to thank management,
Prasad also
teaching-
has come.
yes, sir. Management, teaching, non-teaching staff, technical team for their dedicated efforts. I thank all our attendees and appreciate their enthusiasm to learn. Thank you, everyone. Now I request my co-anchor Neeraj Nair to take over the charge for this further session. Thank you, everyone. Keep learning and stay connected for the further session. Neeraj, if you would continue.
Sir, can I take leave? Thank you. I have another session elsewhere, but that is on specific topic. They do not have that liberty to say general orientation of research methodology. Because you are my friend and well-wisher, Dr. C.M. Rao can ask me at any time anything. So he has given me general topic like. Okay, sir. Thank you very much.
Thank you.
Thank you, sir. Thank you so much. Yes, Neeraj,
Thank you,
please
Nitin.
begin.
As rightly said by Albert Szent-Györgyi, research is seeing what everybody else has seen and thinking what nobody else has thought. A very pleasant and warm morning to one and all. I, Neeraj Nair, welcome you all on behalf of MLNG Society's Manikchand Pahade Law College, Aurangabad, to the first session of one-day online capacity building workshop on research methodology. I now request Dr. D.B. Kolte, sir, to deliver the welcome address. Sir.
Kolte.
Yes, thank you. Thank you, Neeraj. Good morning to all. I welcome to the Honorable Resource Persons, Professor Sumitra Madam, Principal, College of Law, Visakhapatnam, Andhra University, Andhra Pradesh. In these four sessions, there is one day on capacity building workshop on research methodology. I also welcome all the participants throughout India in these four sessions. Respected speakers, Madam is going to enlighten us on the topic of the facets of doctoral research. Without taking your much of time, once again I welcome you all in the four sessions. Thank you. Over to you, Neeraj. Over to you, Neeraj.
Thank you, sir. As quoted by Dorothy Parker, the cure for boredom is curiosity. There is no cure for curiosity. To quench our curious minds, today we have amidst us such a persona, Dr. S. Sumitra ma'am. I would like to take the privilege to introduce her to you all. Dr. S. Sumitra ma'am, who is currently the principal of College of Law, Andhra University, has completed her BSc and BL from Acharya Nagarjuna University, Andhra Pradesh in 1980 and 1983 respectively. She completed her post-graduation MA from Acharya Nagarjuna University, Andhra Pradesh in 1985 and ML from University of Madras, Chennai in 1986. Ma'am has also received many awards adding to her vast accolades, and some of them are L.C. Miller Medal by University of Madras in 1986, Dr. A.L. Mudaliar Prize by University of Madras in 1986, Dr. Perinarayana Murthy Medal by Andhra University in 2002, Best Researcher Award by Andhra University in 2013. She has also received United Nations Fellowship by International Law Commission in 1991 and also Mrs. Mithun J.S. Lamb Scholarship by Women's Lawyer Federation India Trust in 1986. She has also been awarded PhD in 2002 for her work on liability for environmental pollution, law and policy perspectives under the guidance of Professor R.J. Rao in Andhra University. She has worked in a professional capacity as a lecturer and associate professor and later a professor at the Andhra University for a span ranging from 1986 to 2015. Not just academics, Ma'am also has experience in the administrative realm, working as a coordinator for UGC at Andhra University, a convener for the Women Grievance and Redressal Cell, and coordinator of Evening College at Andhra University. As very beautifully said by Niccolo Machiavelli, it is not the titles that honor men, but men that honor titles. It is truly an honor to have here with us, ma'am. Have you with us, ma'am. We are delighted to have you with us, ma'am. Before we proceed, I request all the participants to keep your video off and your mics on mute. Over to you, ma'am.
Thank you, Mr. Neeraj, for all the good words that you have spoken about me. And I first of all thank Dr. C.M. Rao Garu for this great opportunity to be with you and interact with all of you. And Dr. C.M. Rao Garu, the organizer of this meeting, and then Dr. Aparna Kottapalli, and then Netal Agarwal, and Dr. D.B. Kolte, and all the other participants. A very good morning to all of you. And friends, when it comes to research, yeah, I mean, the workshop, I was initially asked to speak about doctrinal research. And friends, at this stage, when we speak about, and Mr. Neeraj, can I share my PPT, or?
Yes, it can be possible.
Will it be possible? Okay.
Oh, yes, yes. Wait a moment, madam. You go ahead. We will share with 1 minute.
Okay. Okay. Good. And friends, already you have had a lot of exposure to what is research. And in research, it is said that you are searching for what is already there, but it is not exactly searching for what is there, but then putting things in perspective and searching for something, and then only it is the interpretation of the researcher that gives a real meaning to the discovery. I mean, merely discovering something is not going to take us anywhere, but it is an analysis, and it is how we link it up to human life and experience. With that is what makes a research something very meaningful. And friends, what I feel is research, or this concept of research, this is more like a natural process. And every human being has that curiosity or the urge to know more, curiosity to know what is happening or what is what, and the urge to know more and constantly improve oneself. And it is, just 1 minute. Yeah, hope the screen is visible to all of you.
Yes,
And then, friends, it is a natural curiosity or the urge of human beings that must have led them to know things. And unknowingly, unmindfully, they're involved in research. So the simplest kind of research probably could be to know why the baby is crying. If the baby is crying, and we said to know the reasons, and that itself is the simplest form of research. And to know what is what, or why something is happening. And people get involved in research for various purposes. I mean, we have different purposes in undertaking research. And if it is something like a formal research, and for example, friends, all human knowledge, it has grown through research. I mean, it is initially through observation, and then understanding the natural forces around us, and then slowly trying to understand also the causal relationship between the what is happening around us, and then why something is happening. And when we come to the concept of formal research, so it could be a the objective could be gaining more academic knowledge, or it could be a degree, getting a degree, or getting some other material benefit. But ultimately, the process would be the same. The purpose of research would be to learn more, and to generate more knowledge. And every research, it is intended to add something more to the existing body of knowledge. And this research it involves a careful consideration of study regarding a particular concern or a problem using scientific methods. And this is a systematic inquiry. This is systematic inquiry to describe, explain, predict, and control the observed phenomena. And friends, I mean, regarding this, Professor Subbarao Garu has already explained what the scientific method is. And I'm even afraid that there could be a lot of overlapping with what he has already mentioned, because he has covered almost the entire field of research. But anyway, I mean, since I am asked to speak distinctly on doctrinal research. And friends, research can be of different kinds, as you all understand. It may be a doctrinal or philosophical, theoretical. I mean, all these are the synonyms. Like, so a doctrinal research or a philosophical research, theoretical research, or fundamental research, or pure research. I mean, this is one kind of research, and one of the earliest forms of research also. And on the other hand, it may be empirical or non-doctrinal, or action research, or field research. You may call it with different names. And we also speak about analytical and descriptive methods, and evaluative research, which is intended to evaluate the efficacy of a certain doctrine. And it may be a comparative research or historical research, qualitative or quantitative. And then when it comes to doctrinal research, when we speak about doctrinal research, this is often referred to as table research or library research, and sometimes it is even jokingly referred to as armchair research also. And then because the whole thing, doctrinal research, it focuses on certain concepts or doctrines or theories, and this is more towards building theories. And the ultimate objective of doctrinal research is to focus on the theoretical aspects of the knowledge in any discipline. And this is mostly academic research. This is not like action oriented and what is happening in the society. But the focus will be more on the norms, or the rules, And pure research or doctrinal research is not concerned really about how the doctrine is, whether and to what extent the doctrine is effective and how it is functioning in the society. And friends, coming from the legal discipline, right, I mean, unknowingly, I moved towards the doctrinal legal research, and almost, legal research, it is to a great extent, the methodology and everything is borrowed from the social sciences research, as those social sciences research methods are more applicable to the legal research also. And hence, doctrinal research and doctrinal legal research, they run parallel to each other. They're very similar. And then the starting point for a doctrinal legal research, a doctrinal research in general, it may be one or more normative propositions as focus of the study. And the research, the entire research, it takes place in the library, or and where we find a lot of materials. We try to locate all the relevant materials. And if it is doctrinal legal research, But this is what, and this is like doctrinal research that we undertake in the field of law, in the field of law. And doctrinal legal research, I mean, it takes into consideration the materials like the appellate court decisions and discussions in the treatises, textbooks or reference books, or the case studies or encyclopedia or the legal periodicals. And these are all the things that make up the materials that constitute the materials for doctrinal legal research. And the researcher, he or she proceeds to read and analyze the materials, and develop a certain line of argument, and which we call theory building. And as Professor Subbarao was aptly mentioning, so like we collect the different facts or different materials and then link them up. We knit them closely, we knit them together through our analysis. And this is a line of argument. This is a line of argument and which connects all the materials. And that is how we try to build the theories with the support of the supporting materials. And then this is also a systematic means. Doctrinal legal research is again a systematic means of legal reasoning and used by lawyers, judges, and academicians. And when it comes to friends, who are the participants in doctrinal legal research? So we know the academicians, the teachers, law students, or the researchers, I mean, who are working on a formal research project. And they're all involved, clearly involved in legal research, doctrinal legal research. And then without their knowledge, the advocates and the judges, they're also involved in doctrinal legal research. And the best example of doctrinal legal research that is, that could be taking place within the portals of the judiciary, we can quote the cases like Keshwananda Bharati, which the judgment, which runs into hundreds of pages. Well, this is a masterpiece of doctrinal legal research. This is where they created, or they rather built, a new theory, that is that of the basic structure of the Constitution. And then for a long time, legal research or research, it meant only doctrinal research, because I mean, we were trying initially to perfect the doctrines, and before we could test them. So improve the normative situation and then perfect the doctrines. And doctrinal research, this is therefore this is also established as a traditional genre of research in the legal field. And in legal field, for a long time, we knew only about doctrinal research, and non-doctrinal or empirical research in the field of law, especially in India, is only of a relatively recent origin. And this doctrinal legal research or doctrinal research is also known as the theory testing or knowledge building research. So we do both the things. We build theory. We also test the theory. We may also test the theory in the light of other doctrines. So, I mean, through facts, the concepts arise. And then when we build up a certain relationship between the concepts, that becomes a theory. That would be a theory. And this is how we build theories in doctrinal research. And we also use the same doctrinal research to test the validity of the existing theories, and also for refining or reforming the existing theories. And doctrinal research is also meant for building knowledge building research, and hence this is also known as the knowledge building research. And it deals with doctrinal legal research. It deals with studying existing laws, related cases, and authoritative materials. Materials will be dealing with them also. What are the materials? And then analytically dealing with all of them analytically on some specific matter. And friends, here we also, let us also be very clear about this research in law and research about law, And doctrinal legal research, it is said that it is based on legal positivism. Legal positivism. Why we say that is, like in doctrinal legal research, we deal more with the enacted legislations. Enacted legislations are those things which are posited, which are properly posited as as a law, as a law. So a study or an examination of these legislations or enacted laws or other principles which have the force of such law, So in the doctrinal research, our search is for what is the law, I hope all of you have also studied jurisprudence, and in that we also come across the distinction between, as Salman actually puts it, there is a difference between law, the law, and a law. A law. So a law, it refers to any enactment or only one enactment, and it can be anything. And law, we are referring to the general body of all the rules and norms put together. And the law, when we say the law, we are referring to a specific legislation, a particular legislation. And then research in law, the doctrinal legal research, it deals with what is the law. What is the law? For example, what is the law relating to right to life and personal liberty? We immediately refer to Article 21. Or if we say, what is the law relating to sports? The law relating to sports, and the body of those legislations which deal with the regulation of sports and conduct of sports or the conduct of the sports persons. So this is the specificity. And then what is law? And then all these things, this is like research about the law. And in doctrinal legal research, we are concerned with what is the law. What is the law? So we focus on a particular aspect, or maybe relating to domestic violence. Take a particular concept, and then what is the law relating to domestic violence in India? So the law, it means it need not be a single legislation, but the body of all those rules or the enacted legislations, enacted laws, including delegated legislation, which include notifications, circulars, bylaws, etc. And then doctrinal legal research, it can be distinguished. This is different from mere literature review. It is not merely reviewing the literature or studying what the materials are there. This is not even content analysis. Content analysis, definitely, it helps us in the collection of data for doctrinal research. But then it is not the same thing as content analysis. And then a doctrinal research is, it is not merely historical legal research. We may be involved in the history of certain norms, or a historical approach also may be taken, but it is not merely historical legal research. And then doctrinal legal research, it studies the legal propositions, the proper legal propositions, and then an exposition of the existing law. We will be involved in the exposition of our understanding and explaining the meaning of the law, and understanding what the law is, And in that process, we would be adverting to all sources of law also, And then often it is said that doctrinal legal research is based on secondary data. And this also, friends, I'll be covering a little later. a little later when I come to the sources of data and the types of data for doctrinal research. And then, but anyway, I mean, this is based on data like conventional legal theories or laws, statutory materials, and court decisions, and the among others. And then a research which is purely relating to what the law is, and then the other kind can be a research about the law. I mean, this may take the form of interdisciplinary research, like socio-legal research, or some economic dimension, adding economic dimension or a political dimension to law. And then in doctrinal legal research, this is mostly expository research. That is, we are concerned with the black letter of the law. What is there put in black and white? So we are concerned only with that, and hence we also call it the fundamental legal research. And doctrinal legal research, it may be undertaken not only for understanding the law, not only for finding out what the law is, and this may also be undertaken for law reform. But however, law reform research, it may be both doctrinal as well as non-doctrinal. And then how do we find out what the law is? Now, if the sole concern of doctrinal legal research is to find out what the law is, so what are the sources? The sources from where we get the law are primarily, this is legislation. This is the legislation and a formal source of law. And then it's not only that formal legislation enacted by the apex bodies, but as I have already mentioned, this also includes all the delegated legislation. And then, friends, a systematic analysis of the case law of the appellate courts. So why we don't consider the lower court decisions is the precedent that itself means that the judgment of a higher court, a general principle laid down by a court during deciding a particular case, and which is laid down by a higher court, and this is binding on these general principles or the ratio decidendi that is binding on all the lower courts. And then the precedent also has got the force of law, and this is a source of law also, and for us, and then custom. There are several customary principles of law, and even in the most developed legal systems also, custom cannot be overlooked. Custom as a source of law, source of any law, that cannot be overlooked. But then one question arises here is, especially with regard to pure research and in the context of Kelson's pure theory. So it is commented that legislation can be a formal source. We understand this looking from the positivist side. And how do you consider customs and precedent also as law? But anyway, since these are sanctioned by law itself or by the command of the sovereign, to be having the force of law, and since they are accepted as such, by the sovereign, so we include them also into the sources of law. But they are not the same thing. Custom is not a formal source as legislation is, but nevertheless it is an important source. And then we could be searching for the authoritative text of the legislations or the authoritative publication of the precedent. And when it comes to custom, so we need to search or wade through a lot of historical material to find out perhaps the transaction by which the custom is a custom or right is created, or specific instances of following of the custom. So this becomes slightly difficult. But with all these things, friends, when a proper, uh, 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 when we properly focus on these sources of law, and then we develop the law by applying it to specific instances. So we can be, the doctrinal legal research can also be highly creative. And friends, for example, Dr. S.N. Jain, he says that case law and judge-made law, these are quite creative in their nature, and they're equally creative. And the best examples could be administrative law and the law of torts. So here, these two disciplines of law, they have grown entirely through case laws, the creativity of the courts, and then the creative imagination of the judges. And then, friends, here again, I think this is slightly repetitive. So DLR involves a systematic analysis of statutory provisions and of legal propositions involved therein or derived therefrom. And then it involves the logical and rational ordering of the legal propositions. And the emphasis would be on the substantive rules of law, and doctrine, concepts, and judicial pronouncements, etc. And then doctrinal legal research is often, this is analytical. When we say this is an analysis, this involves a lot of analysis and a critical thinking. And as Professor Subbarav was also mentioning, yes, the legal materials are the ones perhaps which are known to everybody. Everybody knows what the law is, unless it's such a field that you are undertaking only an expository or some formulative research. There's some exploratory or formulative research. But in other cases, yeah, people do have an idea about what the law is. But what is new in your research, in the doctrinal legal research, is the analysis of the law. And through analysis, we give it a new orientation. And that new orientation, that leads to building a new theory. And then, so hence, we understand that this is going to be an analytical study. Doctrinal legal research, it will be highly analytical and also descriptive, describing the existing things or the state of things. So it may be either analytical or descriptive. And doctrinal legal research, it may also be historical or comparative. So these are again the methods, the different approaches to doctrinal legal research. So we may take a historical approach to the historical evolution, for example, of the law relating to right to information. So we go into the history and the legal events that have occurred in the past, and then the causes, the reasons for the evolution of this. So we go into the history of that and how the doctrine has emerged, the legal doctrines have emerged, or it may even be comparative. Doctrinal legal research may also take a comparative approach, in the sense that we make a comparison of the law periodically. We may make a periodical comparison, like what it was in 1970s or 1980s, and what it is in 2020s, or the 2000 and plus years. So it is like, if we can make a comparative study of law relating to women also. It has undergone sea change during a period of 50 to 60 years. So right from the concept of welfare and protection, now we have reached to the level of empowerment, and then human rights, the conception of women's rights as human rights. So that is how, I mean, we may make a comparison of this within the same system, or we may be comparing our system with another legal system. So Indian legal system, it may be compared to the American legal system. So women's rights or domestic violence, a comparative study of United States and India. So this can be a comparative study also. So, but I mean, and this is just by way of explanation, the difference between a descriptive study and an analytical study. So, descriptive studies, in descriptive studies, we do not develop any argument. Rather, we try to present the existing picture. And this is like, it takes a comprehensive snapshot of a topic. So the existing situation, what it is and how it is. And then, however, when it comes to an analytical approach, so we break up the components, we break up the process into different constituent parts, and then see how these are related to each other. For example, the election results are being announced. So BJP 50, and then Congress 70, and then NDA something else. It comes like that. This is data. But then the whole thing is there in front of you. But then we see BJP and then NDA and Congress. We try to correlate, separate them, and then try to correlate whether BJP has an edge over Congress or BJP. So this is how, I mean, we examine how these parts are related to each other. One is more than the other, or one is equal to the other, or less than the other. So the relationship, the kind of relationship. So this is like an analysis. And then, friends, here we come to the process of research, the process of research for doctrinal research. And friends, whether it is doctrinal or non-doctrinal, several aspects of research are common. The processes are also common. And we start, in any research, we start with the selection of a research problem, and then formulation of the research problem. That is how framing the objectives. I mean, transforming a research problem into a set of objectives. So this is formulation of the research problem, and then framing a hypothesis or research questions. And friends, when it comes to, if it is something like a non-doctrinal empirical study, so, or experimental study or diagnostic study, so having a hypothesis is compulsory. But then in a descriptive study and a pure doctrinal study, hypothesis may be replaced by a set of research questions. And then extensive literature review. So we need to undertake literature review more extensively than in case of non-doctrinal research. Because our research, doctrinal research, is entirely based on the doctrines, or we build. It is not like in doctrinal legal research, we entirely create a new doctrine. Probably one could be doing it, but most of the time, our thoughts, the building a new theory, it's done on a foundation. That is the already existing theories or the literature. So extensive review of literature, and then designing the research, formulating a research design. This is like the blueprint. When to do, what to do, how to do, and everything, every detail. And then this is followed by collection of data, and then processing and analysis of data. And the final stage would be the report writing. But when it comes to a few things which are specific only to doctrinal research. mean, often it is said, it is said that doctrinal legal research is based on secondary data, and in contrast to primary data. So, friends, primary data is that which is collected from the society, from the respondents, or from the field directly. And this is like when you administer a questionnaire, or you observe a phenomenon, or when you interview people. So this is how you are gaining first-hand knowledge about what it is. And from the field, and this is the empirical data, or primary. This is known as the primary data. But in doctrinal legal research, for us, the entire data is from the documents. This is the documentary source for us. Work is already done, and then from those materials which are available in the libraries in the form of treatises or other things, so we gather the relevant materials. But then, does it mean that secondary data is something inferior to primary data? As in case of primary evidence is superior to secondary evidence? No. It's not like that. It is not like that. So secondary data, we mean when primary data is that which is generated by the researcher himself. So it is in that sense it should be taken. But secondary data in the context of doctrinal legal research is something which is already generated by somebody, but we are making use of it, but with our own analysis, and then even secondary data, it should be taken from primary source. The primary source would be the original materials. So that is what are referred to as basic tools for doctrinal legal research. There are primary tools and secondary tools. The primary tools are like the statutory materials, the legislations, and which are published by or under the authority of the government, acts of legislature, rules, notifications, and including the delegated legislation, and the gazettes, official gazettes. These are the most authentic primary sources of law. And then secondary tools. Secondary tools are like sometimes we may derive law or the text of the law from textbooks or reference books or commentaries or publications by private publishers. And there is a presumption that even these are publication of the bare acts or other acts can be done only with the permission of the under license from the government. They are authentic, they could be authentic, but when it comes to deriving law from textbooks or reference books or from commentaries, some commentaries, then we need them, they would be like secondary sources. So we need to be very careful, and in all cases, students are advised to refer to the primary tools or the primary sources of the law. For example, if you want to know what the Supreme Court has decided in William Gasly case, read the original text of the judgment and don't rely on the commentaries given by somebody else, and not even the head notes which you find in some legal periodical, in some journal, because that could be wrong. And perceive everything, read everything by yourself and give your own interpretation, your own analysis to law. That would be the original material. That would be making the use of your primary tools. And in exceptional cases, you could be making use of the secondary tools also. But primarily, it should be there. And then these are the materials, and these are the things that we extensively use in doctrinal legal research. So debates in the houses, the Lok Sabha debates or Rajya Sabha debates published by the respective houses, and case reports, case digests. Case report, it contains a detailed report and a detailed publication, and case digests are like they give you an overview of what cases or how many cases are reported in a particular during a particular period. And then there are case comments, annual surveys, and legal periodicals. And we also have index to what we call index to legal periodicals. The legal periodicals may be there. I mean, some different journals, the Indian Law Institute Journal or the Indian Society of International Laws Journal, Cochin University Law Review, and something, several things are there. And then besides that, this index to legal periodicals, they give you an overview of what articles are published in what journals. So they give you a comprehensive information about many legal periodicals, right? And then there are bibliographies that are prepared. So this is a bibliography is like a source list. A bibliographic index, it gives you the entire material, a list of all the materials that are available on a particular topic. And for example, if I say Article 21, personal liberty. So then a bibliographic index, it might give you a list of all the books available on Article 21, including the textbooks on constitutional law, and then the cases, all the cases that are relevant and articles that are published on Article 21. So comprehensively, you have the entire list of the things. And then we also make use of online resources for doctrinal research. But here one has to be very careful about the validity of the online resources. So is that a genuine website or not? I mean, that has to be verified. And not all the materials that we find online, it may or may not be authentic, And then friends, I mean, the specific processes which are specific to the doctrinal legal research. So preparation of bibliographical index. So this is the starting point for any research, and especially doctrinal research. So you prepare a bibliographical index. I mean, if it is already there, we may make use of it, but the person who created that could have missed something else. So it is always better that a student, a researcher prepares one's own bibliographical index. And then we also resort to content analysis for collection of data, and then web sources. I mean, there are many legal databases and legal softwares now. And younger generation people, they know more about the digital resources and then online resources better. Like the Legal Pundits or Manupatra, Westlaw, LexisNexis. I mean, like that, we have several databases or softwares available for doctrinal research. And then, yeah, friends, Professor Subbarayagar was referring to scientific method. And in that, he was referring to the method deductive reasoning and then inductive reasoning. And doctrinal research methods, they are deductive in their nature. So doctrinal research, it proceeds on the basis of three basic premises, doctrinal legal research. It's like the major premise. Deduction is from a general rule and apply. There is a general rule, we apply it to particular facts and then come to a conclusion whether a specific outcome will be there or not. So this is a process. And in legal research, doctrinal legal research especially, so we proceed, I mean, this would be a deductive reasoning. So the major premise here is the generalization or the existing law and a general law, and which requires a specific legal outcome when particular facts exist. See, like theft. Theft is prohibited. The punishment for theft is 3 years, let us say. And then we have a description of what is meant by theft. And if a person does these acts, then it amounts to theft. And then the outcome is like punishment. So the rule prohibiting theft and then describing what is theft This is the major premise. And now we test whether what is done by X, it amounts to theft or not. And if it amounts to theft, and if it fits into the major premise, the minor premise is the factual situation. Right? If the minor premise, if it fits into the major premise, then there will be the desired outcome. There will be the punishment. There will be punishment 3 years or 2 years or maybe whatever it is. So the conclusion. So this is how doctrinal legal research may be proceeding. And then doctrinal legal research and hypothesis. While formulating a hypothesis. So I'm not going to go into how we and what is hypothesis and how we formulate it, but hypothesis basically it involves testing the concepts. I mean, it involves the use of concepts, and the correlation between the concepts. And hypothesis roughly is a statement relating to the relation between the different concepts, how the concepts are related in the study, and that will be tested. That has to be tested. And then in doctrinal legal research, we will have to be very careful about formulating a hypothesis, because hypothesis must be something that is capable of testing on the basis of doctrines, on the basis of the existing norms or doctrines. So if I say that Section 9 of Hindu Marriage Act is, it violates Article 14, then I should be in a position to show how, whether there is something inherent in Section 9 which violates Article 14. But I cannot say that because in practice, it works to the disadvantage of the women. So then it becomes a socio-legal research or non-doctrinal research. So a hypothesis in a DLR or doctrinal legal research, it must be one which is testable on the basis of the doctrines, not testable on the basis of primary data. So care must be taken. And then I think this requires a lot of explanation also, but let me very briefly mention that we also need to operationalize or delimit the concepts. So in any research that we'll have to do it, so fix the limits or delimit the concepts and operationalize them. Like if I say poverty is something which I'm using, the concept I'm using, then what is meant by poverty, that should be clearly defined. And is it below 10,000 per month, or based on income, or based on property? That should be clearly mentioned. So then we say that we have converted this concept into a variable, and then we test the relation between variables in a research. And then when it comes to one more aspect of doctrinal legal research is like how do we give references or citation? And we need to be very, very careful about referencing or citation, because we base mostly, we depend on the doctrines or the documentary sources, and hence it is not your own data, but it is somebody else who said it. So who said it, where it is said, and then how it is helpful, we'll explain anyway. But who said it, and where did he or she say that? And we need to mention it. That is through references, giving references or citation. And for example, friends, when I say any law that takes away the personal liberty of a person should be just, fair, and reasonable. This is what the Supreme Court has said in Maneka Gandhi's case. So then I need to give full citation, like Maneka Gandhi versus Union of India, and then AIR 1978 Supreme Court and page number so and so. This is when I give all these details, this is citation and this is referencing. And that has to be taken care of very, very well in doctrinal legal research. And friends, I mean, the materials that you quote, they should be identifiable by the, I mean, you should also show that they're authentic, and they should be locatable by the reader. The reader should be in a position to locate the material that you have used. And then friends, these are a few things that are unique to or peculiar to the doctrinal legal research or doctrinal research in general. So the entire focus would be, I mean, let me repeat, in doctrinal research or doctrinal legal research, we will be focusing more on the doctrines, and we take a certain legal proposition and then try to understand its meaning, and then we also try to gather the entire law that is available and present through a systematic analysis. Through a systematic analysis of all the materials available, we present what the doctrine is or what the theory is. And then this, I mean, for a long time, doctrinal legal research has been the only way of research. So I'll be concluding in just 2-3 minutes. Please bear with me. And then the advantages of doctrinal legal research are many. So this is simple and provides quick answers to the problem. And as the researcher is continuously engaged in the exposition and analysis of the legislations. And also, I mean, it has made immense contribution. The contribution of doctrinal legal research is very, very significant. It's very significant. And then this doctrinal legal research, when we knit the legal principles together with sound reasoning, and it leads to a well-developed law. So a close analysis, and that leads to clarification of the law, or it may even create a well-developed body of law, like the examples, the law of torts or administrative law. And then DLR, it helps in understanding the law properly and the legal concept or doctrine. And in the process, we can also point out the inconsistencies or gaps or the lacunae or uncertainty in the law. And whatever gaps are there, they may be pointed out clearly through doctrinal research. And then the loopholes or the ambiguities. And we can also, through the same process, through the same doctrinal research, try to plug in the loopholes or clarify clear the ambiguities. And this may, I mean, when we point out to the loopholes, etc., it may also lead to reform or legal reform or development of the other parallel doctrines. And then it said, I mean, DLR is also capable of building theory, and also predicting what its future is going to be. I mean, how it would be in its future journey. And above all, doctrinal research, it provides a sound basis, a firm basis for non-doctrinal research also. Now, because friends, I mean, when we have a solid theoretical basis, and only then we can think of testing how the doctrine is functioning and how it is working in practice. So, I mean, doctrinal research is often compared to its nearest rival, that is the non-doctrinal research. And in non-doctrinal research, I mean, in doctrinal research, we build the theories, whereas in non-doctrinal, we test the theory. And this is in doctrinal research, this is like a pure doctrine that we would be dealing with or we would be developing. But in non-doctrinal research, we would be studying the relationship of the doctrine with other disciplines, like how a law is obeyed, to what extent it is accepted by the society. And unless we test those things, it becomes difficult. I mean, anything like law reform would be difficult, And then doctrinal research is research into what is the law. And non-doctrinal research, we say it is research about what law is. And friends, I mean, it is, there are, with all the advantages of doctrinal legal research, let us also point out to the limitations. The limitations are also there. Here, doctrinal research, it mainly focuses on what the law is, and generally, it is presented, when it is presented by the researcher, it is colored by his perceptions. And hence, doctrinal legal research or doctrinal research, for that matter, it is likely to be subjective. And through doctrinal research, we only understand what is happening, and it is difficult to understand why it is happening. Why something is happening. Why something is happening can be understood only by non-doctrinal research. And then when we in pure research or doctrinal research, I mean, I'm not going into all these points for lack of time. And then when we undertake pure research, in a way, we are separating this discipline, law, for example, from other allied disciplines. But if we do not study law when we totally separate law from other allied disciplines, I mean, our knowledge of law, our understanding of law may not be perfect, may not be complete also, because every law has a certain historical, economic, political, and sociological context. And so it has to be studied in that context, and that context, sociological context. So that may be done by non-doctrinal research or empirical research. And friends, for law reform or for plugging in the loopholes also, I mean, a non-doctrinal research may be necessary, but see, doctrinal research and non-doctrinal research are like, both are complementary to each other. And I mean, this is just symbolically to show, it is often said that doctrinal research is very simple, because you sit in the library and then do it. And non-doctrinal or empirical study is about going around, running around in the society. No, and it has got a vast body of materials to be exhausted and several things. And unless the researcher also is very keen and then intellectually sound, and with great clarity, he is able to expound the existing law. I mean, doctrinal research cannot be really effective. And hence, friends, I mean, let me conclude saying that, yes, doctrinal research is important, and this is like the foundation for the development of many other resources and non-doctrinal research also. So I profusely thank the organizers for this wonderful opportunity, and I apologize if I have exceeded my time. And thank you all. Thank you very much.
Neeraj, go ahead.
As rightly said by William Arthur Ward, the mediocre teacher tells, the good teacher explains, the superior teacher demonstrates, and the great teacher inspires. So thank you, ma'am, for being such an insightful, for giving us such an insightful delivery into the topic and inspiring us. Now, to sum up the session, it is important to thank and express sincere gratitude to the efforts put in by a lot of. I will take the privilege to propose the vote of thanks. On behalf of MLNT Society's Manikchand Pahade Law College, Aurangabad, I extend my gratitude and sincere thanks to our resource persons, Dr. S. Sumitra ma'am, for taking out time and enriching us with such a knowledge. Further, I'd like to thank our principal, Dr. C.M. Rao sir, Vice Principal, Dr. S.N. More sir, IQAC Coordinator, Dr. Aparna Kottapalle ma'am, for their persistent efforts in arranging this online workshop. I'd also like to thank Dr. D.B. Kolte sir for the welcome address and all other teaching, non-teaching staff and IT team for making this session a success. Last but not the least, I would like to express my gratitude towards all the attendees without whom this session wouldn't have been possible. Now, before concluding the session, I request the attendees to stay tuned for the second session of the workshop on significance of non-doctrinal research methods in legal research by Dr. Vasundhara Kamath. With the permission of our principal, Dr. C. Rao sir,
With your permission, I leave.
and all the
Thank
dignitaries present, I hereby declare this session as over. I hand the further proceedings to Dr. Ms. Divyanshi Muktia. Thank you.
Am I audible, ma'am?
Yes, you are audible.
Go ahead.
Good morning to one and all present here. Myself, Divyanshi Mugdia, student of LLB first year, Manikchand Pahari Law College. It's my privilege to welcome you all in behalf of MLNG Society, Manikchand Pahari Law College, Aurangabad, on one-day online capacity building workshop on research methodology. We are fortunate to be a part of this esteemed institution who constantly make efforts to flourish their students by imbibing knowledge by providing such workshops from the most expertise person out there. Now, I would like to request Professor Girbane ma'am to propose the welcome address. Hello.
You're
Devanshi,
audible.
please.
Go ahead.
Hello, ma'am.
Girbane madam, are you there? Girbane madam.
Sir.
Aparna.
Yes,
No,
yes.
please go ahead.
Pratibha madam, over to you. Please continue with the welcome address.
Yes, sir. Yes, madam. Yes, madam. Respected principal, sir, resource person of this session, dear participants, on behalf of MP Law College, Aurangabad, I welcome you all in the second session of one-day online capacity building workshop on research methodology. For this second session, we are having with us Dr. Vasundhara Kamath from Washington, D.C., and she is going to enlighten us all on the subject, significance of doctrinal research methods in legal research. I welcome you, madam, on behalf of our institution. And without wasting much time, hand over mic to the bench. Thank you all.
Okay. Thank you, ma'am. As we all know that now research has been a part of every human being, be it a school kid completing his project or an advocate researching about their cases. Research methodology is a way which systematizes the problem-solving process. So today we have with us Dr. Vasundhara Kamath to address us on significance of non-doctrinal research method in legal research and to add permanent sweetness to our knowledge. She is a non-profit professional using data-driven methods to increase women political participations and experiences of research above 10 years experiences with doctrinal and empirical method, skilled in qualitative and quantitative data collection, analysis, and visualization. Talking about her area of expertise, research methods, mixed methods, women of political data analysis, data visualization, report writing, editing, and so on. She has completed her master's on public policy from the Georgia Washington University, Washington, D.C. In 2016, she has completed her Doctor of Philosophy from Nalsa University, Hyderabad, India. Talking about her professional experiences, presently, ma'am is a running star in Washington, D.C. When we talk about program and evaluation and development management, as part of evaluation and development team, using data-driven strategies for growth of organization, design quantitative and qualitative data collection protocols, collect rich data through stakeholders, focus group, and interviews. analyzed data, and developed visualization for grants, report, and fundraising pitches, and many more. In 2013 to 2015, she was an assistant professor in School of Law, Christ University, Bangalore, India, where she developed and taught courses of constitutional law, feminist jurisprudence, and legal writing. In 2019, some of the programs which she has assisted are conducted research on general approach and theories of changes in development context, with a focus on education, political participation, and violence prevention of many more. Dr. Vasundhara was a staff assistant intern in Public Service Project, Wilson Center, Washington, D.C., where she analyzed data-focused Gender Equality Index and author report on challenges to political participation of women in Pakistan. Assisted in research on pathway to increase women representation in politics with a meta-analysis of data 75 countries. Currently, she is doing systematic review of studies on women political participation, where she is using the transformative paradigms to systematically review mixed method research. She studied on women political participations across the globe. We wholeheartedly welcome you, ma'am. We are truly honored and blessed to have you with us and looking forward to gain as much as knowledge we can. Before proceeding with the session, I would like to request all the participants to switch off their mics and cameras for an uninterrupted session. Without further delay, I would request you, ma'am, to carry with the session.
Thank you so much, Divyanshi, and thank you to the organizers of this workshop for inviting me for this presentation. I really look forward to engaging with all of you and discussing some elements of non-doctrinal research in research methods in legal research. And as Divyanshi mentioned in my introduction, I think what is relevant from my experience to this discussion is that my primary background was in law. As she mentioned, I have a PhD in law. I was teaching at a law school, and I started with the ideas of doctrinal research. My training was primarily in that. And it wasn't until about 4 years ago that I kind of shifted from doctrinal research to more empirical research methods. So that's why I'm really interested in seeing how both these research methods sort of merge and what we can do to take legal research forward using methods that are considered non-traditional. So let me go ahead and share my screen really quick. Is my screen visible?
Yes, ma'am, it's visible.
Okay, thank you. Yeah, so today I will be speaking about the significance of non-doctrinal research methods in legal research, as you already know, and I will take about hopefully 40 to 45 minutes so that we still get some time for some sort of interaction towards the end of the presentation. So I will try to keep a track of time. And before I begin, before I give the structure of my presentation and really delve into anything at all, my first question to all of you is, what do you think the purpose of legal research is? So I want to start by getting some input from you. If you can just leave in the chat what you think the purpose of legal research is. Why do we conduct legal research? And I promise this is connected to something I'm going to be doing later on in the presentation. So I'll give you about 30 seconds. Just think about what's the purpose of legal research? Why do we do legal research? And then let's move on from there. Discovery of truth. Thank you, Vijay. There are no wrong answers. So you can think about what is relevant. To win cases, Vedya, thank you. Very relevant. For getting more clarity about the issue, for finding legal solution, to find the irregularities in laws, very interesting. To identify the problem, okay. To find something new. I'll give you about 10 seconds more. Getting evidence, okay. Law changes for the changing demands of people and society for making people's need research. Laws need research. Okay, to locate the relevant authority that will help in finding a solution to a legal problem or issue. Okay, keep them coming. Interpretation of law. I will pause that for now, and we'll come back to the why do we do legal research part later on. But again, like I mentioned, it's connected to something that we're going to be discussing later on, right? But before I begin with the actual presentation, I wanted to go through what the format is going to be, right? So my topic for today is the significance of non-doctrinal research methods in legal research. So throughout the presentation, my intention is basically to deconstruct this title a little bit, to kind of pull apart at the different terms that are mentioned here and try and understand what are we trying to understand through this title, right? So if we are looking at legal research, right, what does that mean? What is research? What is legal research? What are non-doctrinal research methods? And ultimately getting to what is the significance of all of this in legal research. So I basically want to start with just deconstructing the title, and hopefully by the end, we will get a better sense of what is the significance of all of this to what we are doing in our day-to-day lives, right? So to start with, I'm going to be focusing on the last term in the title, which is basically research, right? What exactly is research? And the reason I'm doing this is because we need to have some foundational things, right? We need to have agreement on some foundational things before we understand what are non-doctrinal methods, what is the significance, etc. Right? So I want to kind of take a step back and think about the larger picture of what is research, why are we doing what we are doing, and how is that connected to the purpose of law in general, right? So what is research? If we look at a generic definition of research, right? Generally, if you search on the internet, this is basically what you will get, that research is the systematic investigation into and study of materials and sources in order to establish facts and reach new conclusions. So the things that I have highlighted here, the bolded words or terms are basically the things that stand out, the operative parts of the definition, right? So first of all, research is the systematic investigation. So if we simply sit and think about something and then we write an essay on it, that is not considered research. There has to be some sort of a systematic element necessary, and there has to be some sort of a structure involved in it, and then we can call it research. So basically, what we are looking at is some sort of a framework. When we are doing research, we need to have some sort of a structure, some sort of a framework in mind. Otherwise, it is not considered as research, right? The second part is that it says it's the study of materials and sources. So basically, again, we're not doing research in a vacuum. We are relying on certain external things, such as materials and sources. Again, if we are sitting on a couch at the end of the day and simply thinking about things, that may be processing information, but that does not necessarily in and of itself constitute research. So there has to be some external factors, right? And the last part of the definition is that why is this done? In order to establish facts and reach new conclusions. So there is some element of finding truth in this definition, right? And generally, if you look at scientific research, the focus more is on truth seeking, trying to find out what the truth is. And that is the goal of research, the purpose of research. Again, we're not simply thinking, we are not simply doing something. There is an ultimate purpose or goal associated with it. So this is the definition of research, a generic definition of research, right? Now, moving ahead, the next part, let's expand that a little bit more. We're not just focused on research, we're here to talk about legal research. So what exactly is legal research? A lot of you mentioned in the chat, like different definitions, right? Everything from, someone did mention finding the truth. So there is some amount of, there's that overlap with scientific research in that sense. But on the other end, someone also mentioned that legal research is basically about winning cases. It is about presenting evidence before the court to help your client win the case. So it is a very narrow definition of the term, but that is something that we actually do, right? So that is also legal research. But again, going back to a generic definition of legal research, if you search online, you'll find something like this, which is basically legal research is the process of identifying and retrieving information necessary to support legal decision making. right? So this is a generic definition of legal research. So again, thinking about the definition of research that we saw earlier and thinking about specifically legal research, is there an overlap? Are we really doing research in that sense of the term when we are talking about legal research, right? Are there similarities? I would say yes, because legal research is the process. So the fact that there is an underlying process given there again suggests that there is some sort of framework in place, which means there is some sort of a structure that exists for us to do legal research, right? So that is one similarity. Secondly, identifying and retrieving information. Again, the focus is on external sources. That is something we rely on to do research. So that is also similar to the definition that we saw earlier. And the last part is that it is necessary to support legal decision making. Now, this is a little bit tricky because we are not necessarily or explicitly saying that truth seeking is a ultimate goal or purpose of legal research. We are saying to support legal decision making. So again, going back to what someone mentioned in the chat, that it is to help win the case, right? So if you think about an ordinary courtroom scenario, when I am one of the advocates, for example, for my client, my primary purpose is not to present the truth to the judge. It is very subjective, right? I know what my end result, I know what I want the end result to be. I want my client to win the case, right? And that is why all the evidence that I present, all the arguments that I make, and all the research that I do for it is sort of done in reverse, where I know what the ultimate goal is, and then I'm working my way back. So in a sense, I am supporting legal decision making, but in a very narrow sense of the term, I'm also doing this solely for the purpose of helping my client. And that is basically working in reverse, where I'm not necessarily trying to find the truth. I may be part of a larger machinery that is helping to find the truth, but that is not my goal of legal research. I am just focused on what my client wants, regardless of what the truth may be. So that is something that we do need to keep in mind when we are thinking about legal research and trying to separate that from any other kind of research that we are concerned with. And this, I think, is really relevant when we are looking at the larger picture of the methods that we use, etc. So moving past the definition. Right. So we mentioned framework earlier, right? So what exactly is a framework and what exactly is the legal framework? So I mentioned that framework basically is some kind of a system or some kind of structures in place that help for any one kind of research. So when we're talking about law, the legal framework basically relies on some kind of principles that we have in the legal system, right? So we have some kind of documents that are in place that basically dictate the relationship between two parties. So you can have anything from a contract to legislations to the constitution of the country. And in between, you have things like policies, regulations. All of this basically constitutes the legal framework. So Sumitra ma'am, who went before me, explained this in detail. But basically, we are limiting ourselves to this kind of a legal framework. We are basically looking at the applicability of a certain rule or a certain provision in a given scenario. And we are looking at the underlying principles associated with that. So it is kind of a narrow framework where we know these are the documents we have to look at. These are the principles that we have to rely on. And it is with the help of all of this that we are conducting research at the end of the day. So that is the structure in which we are operating. We are relying on these documents when we are conducting research. And that is important to remember, because if we are looking at the legal framework from that narrow mindset, basically we identify that it is associated with a normative character. And this is also something that Sumitra ma'am touched upon. That's why I'm not going to go into details. But I think as we move ahead with the framework for the non-doctrinal methods, etc., it becomes important to separate these two out. So it's something that you need to keep at the back of your mind as we go ahead with the presentation and we think about other ways as well. Right. And in the definition of legal research, we also focused on information. We focused on sources. And we obviously know that there are two kinds of sources. There are primary sources and secondary sources in legal research. But basically, this is what you do by identifying concepts, identifying principles, identifying legal authorities, and then using that analytical approach as you're trying to dissect that. And that is basically what legal research is. Those are the kind of sources that you have in legal research, right? So now that we have all of that clear, going back to the idea of, is this really about truth finding? Is this really similar to the scientific research that we have in other arenas, right? So is it similar to that? And I thought that this quote by Monroe Smith, which was quoted by Justice Cardozo, is very interesting because Monroe Smith basically tries to say that when you are applying, and this is basically with regard to the application of case laws. If you're thinking about judges as applying case laws, this is where this, that is where this definition kind of fits. Not definition, the quote fits, which is basically that anytime you have any consideration that is made before the court, right, and the court gives a ruling, that is basically like a working hypothesis, because lawyers may be arguing on different sides, right? So their purpose for conducting research may be to help their client. But if we are thinking about the justice system as a whole, and if we are thinking about judges, right, the judges are basically trying to understand what these truths are, right? It is the job of the judge to really identify the principles associated with a case and try to refine them over a period of time. And they are the ones who are actually seeking the truth. So according to this quote, basically we as if we are talking about ourselves as advocates, we may not be after the truth, but the justice system as a whole is sort of created to get to the truth. And every judgment is kind of a working hypothesis. So every time a judge is reviewing a judgment, reviewing precedent, they are basically looking at the applicability of that hypothesis and whether that hypothesis needs fine tuning, whether we need to review that further, etc. So there is an argument to be made that even when you're looking at purely doctrinal research and purely legal research, there is an element of truth finding in there, right? And that is basically to do with legal research. Now, of course, I've been talking about concepts as a whole, so that's why I want to go into some examples, right? So I will be using one example throughout the presentation. Because I come from the area of women and politics, I'll be using one broad concept, right? Women and politics, and see how the approach in the doctrinal method and non-doctrinal methods differ, right? So as an example, if we're talking about representation of women in governance, if our research topic is about women in politics in India, for example, right? And if we are employing a strictly doctrinal method, then we are probably going to be looking at concepts such as affirmative action. We're going to be looking at provisions such as Article 243D of the Constitution, which basically speaks about reservation in panchayats, because that is a core area of representation of women in governance in India at the moment. But basically, our research is by and large going to be limited to this. We are going to be looking at principles, we are going to be looking at provisions, and that is basically what legal research is generally going to be about, right? And we are going to be using the same example later on to see how we can do research differently. So please keep this example in mind, right? We are going to be talking about representation of women in governance. Right. But going back to the title that we have, right? And in the next part of the presentation, I will be focusing on non-doctrinal research. We have looked at what research is. We have looked at what legal research is. Next, we are going to be looking at what non-doctrinal research methods are. So we'll start with what is non-doctrinal. And because it is a negative, non-doctrinal, right? It is the negative of something. We'll start with what a doctrine is. And this is also something that ma'am covered in the previous presentation. So I'm not going to go in great depths into this. But basically, it is some sort of a framework, right? Again, there are these principles, there are these legal provisions, judgments, etc. And we are making our research is basically within this framework. That is what the doctrine is, that we are applying something that already exists. Again, it is very normative, it is very positivist, and we need to keep that in mind when we are thinking about this legal doctrine, right? But one thing I do want you to think about is we have looked at, law is about employing some sort of a framework. It is about using external methods, and it is about having some sort of a purpose, right? So if we're thinking about legal research, all of those factors are there. We do have a framework, we do have laws, principles, etc., and we do use them, right? We have external factors that we use legislations, we use primary and secondary sources, so we have that. And we have a purpose for why we are doing legal research. We are helping legal decision making. So all of those factors are basically satisfied. So what we are doing in law is definitely research. So why do we have to look beyond this doctrinal method at all? Why do we have to look outside of the framework that already exists, right? And it would have been totally fine to use the method that we have right now, the framework that we have right now, where we are solely basing our research on the precedents and all of those things that we discussed earlier. It would have been fine if law was operating in a vacuum. But unfortunately, that's not the case. Or fortunately or unfortunately, that's not the case. When you speak about law, there are all of these different factors that are associated with law, right? We have the economic, the political, the social, the moral, connotations of law. There is a lot of intertwining between all of these concepts and all of these independent frameworks, if you will. And that is where it gets complex, right? That is what makes the whole context in which law is situated very complex. A lot of research that we are actually doing is situated in a complex context. And that is why it is not enough for us to simply rely on principles and judgments and all of those things. That's why we need to be looking outside of the prism of the legal framework and look at what are the other methods that are available and what are the other frameworks that are available that we can employ when we are doing legal research. But just to go into the complex context a little bit more, note that I used the term complex, and this is by no means similar to complicated. And this is kind of a small deviation from what I'm explaining, but I think it's important for us to note this because there are simple scenarios. The context can be simple, right? Where we know what the solution is and everyone agrees that that is what the solution is. And that is a simple context. As an example, we all know that if we wear seat belts in our cars, the likelihood of accidents reduces. There is a certainty of the solution. We know that if we do that, we are less likely to get injured, right? And everyone agrees that that is the solution, that we need to wear seat belts. So that is a simple situation, right? A complicated situation will be, on the other hand, is where there is some idea of what the certainty of the solution is, but there isn't necessarily an agreement on the solution. So if you look at the, say, gun reform in the US, right? It's a huge thing that basically whether we need to have background checks before people can get guns or not. Now, there is certainty that if there is some sort of background check system in place, then people are less likely to get injured. Again, gun crimes will reduce if there are background checks done before issuing guns to people. There is certainty of the solution there, but there is no agreement on the solution. And that is what makes it a complicated scenario, right? So we know that a solution exists, but there isn't necessarily an agreement as to the solution. So that is where things become complicated, right? And the last level of complexity is an actual complex scenario. Now, going back to the example that I spoke about, women in politics, right? If you look at governance of women's representation and governance, for example, there isn't necessarily certainty as to the solution. If we say we want 50% representation for women in all forms of government, we don't necessarily have a solution to that yet. We don't know how we are going to get there. And you can use that same thing for a lot of different things, right? If we want equality in society, do we really know for certain we can do this and it's going to work? We don't have a magic bullet like that, right? And there isn't an agreement on the solutions also. We have a lot of proposals. For example, we can be talking about reservation for women, right? But there isn't agreement on the solution. We can be talking about capacity building workshops for women. But again, we don't have agreement as to the solution. And then there are all of these social, political, economic factors that are in play, right? So that is what makes a situation complex. And if you look at large, like basically complex research topics that we undertake, when we're talking about constitutional principles like equality, liberty, etc., these are all complex scenarios because it doesn't, like I said earlier, it doesn't exist in a vacuum. We are looking at all of the possible factors associated with that scenario, and that is what gives it that complexity. And my argument here is that because the situation is that complex, because the context in which we are operating is that complex, we cannot rely on that single simplistic legal framework to find solutions to problems. That is why we need to look outside of the legal framework to get a better understanding of the problems that we have so that we can find more holistic solutions to that. And that is where we go back to non-doctrinal methods. So that is where we look outside of the legal framework and we see what are the other methods available, what are the other approaches available that will help us understand the context more. Right. So with that background, I'm just checking the time here. Right. So with that background, let's look at what non-doctrinal research is, right? So basically, this is research that uses methods from various disciplines, right, to generate empirical data that answers research questions. Now, I was a little surprised to see that the term non-doctrinal is not necessarily as common, or the term isn't as commonly used as empirical. So basically, it is considered as a binary where you have doctrinal research on the one end and empirical research on the other. So these terms may be used interchangeably for now, right? So I will be speaking about empiricism and I will be talking about non-doctrinal research, and understand that in this context, they both mean the same, right? So basically, going outside of the legal framework, non-doctrinal research or empirical research is basically where we are using methods from other disciplines to look at the same research questions, right? Now, in this regard, we are relying on experience and not just logic. So we are not just analyzing information that is available to us. We are looking beyond that and getting sensory experiences. We are relying on experiences. So as resultantly, it is wider in scope, right? So because we are talking about empirical research, what is empiricism, right? So like I mentioned earlier, it is basically about sensing. It is whatever you can't sense cannot be necessarily evaluated, cannot necessarily be analyzed, right? And when I'm mentioning this, I remember a movie that was released a couple of years ago called Aankho Dekhi, where Sanjay Mishra, who was the lead character, basically refuses to believe anything that he can't see. So there has to be some sort of a sensory experience to really understand that this exists, right? If I can't see something, it does not exist. I mean, of course, we're not going to that extreme, but we are basically saying that knowledge comes from what we can sense, right? So if we can observe something, then we can deconstruct that, we can analyze that, and we can use that to understand our situation, understand our problem, right? And that is the focus in empiricism, what we can observe, what we can sense. And of course, that gets a little bit more complex as we move forward, but that is basically what we need to remember, right? So again, going back to this example of representation of women in governance, right? Remember when we used a purely doctrinal method, we were looking at concepts such as affirmative action, we looked at provisions of law. But if we are using an empirical approach, right, what more can we do? What is the situation? What are the approaches going to tell us that we did not know before when we just used the legal framework, right? So we have provisions in the Constitution. We have other legal provisions that make it easier for women to run for office, right, to contest elections. But if we are using the empirical method, for example, we can go and ask women, do you really know about this law, right? Because if there isn't awareness of the law, how are they to make use of the law, right? So it is, understand that we are kind of going to, we are pushing the boundaries of legal research a little bit. We are not just focused on what the law tells us or what the law ought to be. We are also looking at what is the situation on the ground, right? Because empiricism or empirical research is also, or the applicability of that in legal research is also associated with this idea of welfare state. Because again, law does not exist in a vacuum. Law, and the applicability of law has implications on people, right? We're not just talking about abstract theoretical concepts. This changes people's lives. So we want to know how these lives are being changed. We want to know what the impact is. And that is where this empirical research helps us. So in this context, we will get a better sense of the awareness of law, right? Are women really aware of the law? And not just women, everyone. Is there awareness of law, right? So we can go on the field and actually ask people, are you aware of this law and what their opinion of the law is, right? We can understand what the impact of the law is, and I'm going to be talking about this a little bit more later on. And replicability, right? Because if we know that there is a successful legal framework in one place, if we know that there is a provision in one place, and we want to replicate that elsewhere, we just don't want to take that from one place and apply to the other, right? And this goes back to comparative analysis, for example, right? We all do this in legal research. We compare, you know, the situation in America and the situation in India. But what empirical research forces us to do is try to analyze what is the context in which this is working in the US. If the number of women in government in the US is relatively higher, it's not. But let's take it, or say in Rwanda, right? Rwanda has the highest number of women in government, right? So if we want to do what Rwanda did and we want to increase women's representation in India in politics, right? What is the scenario in Rwanda? How did it work in Rwanda? And is it possible for us to replicate the legal aspects in India? That is what we want to try and understand. And through empirical research, we're actually able to do that. Because then we're not just looking at what the law says, we're also looking at how was the law applied, right? What is the situation on the ground? What exactly happened for that law to be implemented, and how is it working? All of those factors we do look at. So all of these things, empirical research helps us grasp better. And in the next part, we will be talking more about how exactly we can do that. And that is where the methods come in, right? So we got a sense of what non-doctrinal research is, and now we'll focus on what the methods are. Right. But before we continue, one thing I do want to clarify is the difference between method and methodology, because I don't know about you, but for a long time, you know, when I was a student, long back, I was thoroughly confused about what the difference between method and methodology was. And I know in various proposals, I have mixed the two, and I don't want you to make the same mistake that I did. So methods are basically the tools that we use, right? When we are conducting research, what are the tools that we have in our hand? And if it is scientific research, then you have like physical tools. Here it may be a little bit more abstract, but methods are basically the tools that we use to do our research. Whereas methodology is basically how did we decide to use those tools, right? So just to give you an example, if we are writing the methodology section for, say, a proposal, right? In the methodology section, it'll be really long, and we will clearly lay out, this is the problem, this is what we are trying to identify. And in order to understand all of these things, these are the tools we are going to use. So all of the explanation is the methodology, but the actual tools that we are using, right? Maybe interview, maybe observation, all of those tools that we have, those are specifically the methods. So please don't confuse the two. Methodology is the, you know, you're explaining the process, and the methods are the actual tools. So please get that in your mind, because I wish I could go back and tell my, you know, younger self that these concepts are important and not to be mixed. So that's why I want to stress on this. Right. So the next thing I want to say, these are also not methods. We are going to be talking briefly about approaches because they are all linked. But what is an approach, right? Approach is basically, in empirical research, it depends on what data you have. And when I say data, you may be thinking just in terms of numbers. That is not necessarily true. Data can be a lot of different things, right? So depending on what data you're using, your approach is going to be different, right? So if you're only relying on numbers, then it is quantitative approach. If you're relying on anything apart from numbers, then it is a more qualitative approach. And then there's something else called mixed methods, which we are going to go into later. But these are basically the approaches that exist in non-doctrinal or empirical research. And just as a reminder, again, these are not methods, these are approaches, and there is a difference, and we'll get to that as well. So going to the first approach, right? Quantitative approach. Like I mentioned, it is the ability to quantify data. meaning there is some numerical element. Numbers are involved here, right? And again, there is a focus on objectivity. This quantitative approach is generally what you see in the sciences. I did an experiment. I got all of this data. This is the conclusion I reached, right? Of course, you start with a hypothesis. You did the experiment or you did some sort of observation, and this is the result that you arrived at. So that is quantitative data. And the findings are generally predictive. And I don't want to go too much into this, but basically, if you have enough data, you can look at patterns, right? And then you can predict what future patterns are going to be. And I think a very good example of this can be all the times we are living in, right? We look at COVID numbers every day. We look at how the numbers have been for the past few months. And based on a lot of other factors, we can predict how the numbers are going to be. That's why there's all of this talk of a third wave, fourth wave. This is all predictive. Based on the data that we have already, we're trying to predict what will happen in the future. And we can very well do this for the social sciences as well. It's not just for the sciences. Then there is explanatory. I think that is explanatory is self-explanatory, which is that, you're trying to explain something through the help of numbers. And then confirming. If you have a hypothesis about something, you're using data to confirm that. So if my hypothesis is that there aren't necessarily enough women in government right now, I have the numbers to show that, and that is sort of confirming, right? But again, understand that this is all sort of positivist, right? It's not necessarily challenging anything that we don't already know, right? So it can be something that is, again, operating in a very narrow kind of a setup. And that is generally how quantitative method approaches are. Now, what are the methods? Remember, we have been talking about approaches. Okay, we're doing okay on time, and I will try to hurry up. So in terms of the methods under quantitative approach, remember we were talking about approaches, right? So specifically getting to the approaches, survey research is a very good example. And just to give you my own experience with that, the survey research is a lot of what I do in my day job, right? We run a lot of trainings for young women, training them how to contest elections, how to get into politics, etc. And my job is basically to design surveys to get their feedback about how our trainings have been, and also try and understand how are they applying what they learned from our training when they run for office, when they contest elections, right? So it is going to be, say, I'm sure you've all answered surveys, right? Even if you give a review in Zomato or Amazon or wherever, that is essentially like a short survey, right? But we are collecting information with the help of that survey. So it can get more complex, but basically we are trying to understand something. Maybe it's people's opinion on something. Maybe it is the level of understanding that people have about something. It can be several different things, but that is generally what survey research is. But there are other kinds of quantitative research as well, correlational research, causal comparative research, when we are looking at the impact of something that is causal, right? Is X causing Y? We can find those things out as well. And then experimental. And if you think that experimental is only for the sciences, that is not true. You have a lot of social science experiments also that are happening. And that is a separate topic in and of itself. Experimental research in the social sciences is very, very interesting. And hopefully we can have a separate discussion on that sometime in the future. But these are all the methods under quantitative approach, right? And again, understand that there is a different section, which is tools, right? Tools basically are the specific things that you use to do the research. So survey research is like a broad concept, right? Under survey research, I can be doing several different things, right? And those are the specific tools. And how do I collect data for quantitative research? If I'm using census data, for example, it is quantifiable, it is in the form of numbers, right? How many people from a particular community live in a particular place? That is a number. That is administrative data because it is by the government, it is official data. But that is a quantitative approach. That is a tool that we are using. I'm getting data from the government about something specific. That is a tool, right? Survey data, like I mentioned earlier, geospatial data, this is like a whole different area of research. Even in social sciences, it's emerging geospatial data. And again, like I can be talking a whole lot about that, but I don't want to deter from what we're discussing right now. But just to give you a sense, these are the tools available, right? So also to give you some sort of a visual about what quantitative data looks like, I'm sure you've seen graphs like this all the time, but here you have exact numbers, right? But the numbers tell you a story. They are telling you in comparison to the rest of the world, where does India stand when we're speaking about representation of women in parliament? And if you look to the very bottom, you have the colors as well, 2010 and 2017. So it's giving you a lot of information. If you have numerical data like this, it will give you a real sense of what the representation looks like, right? So again, if our legal research question is what is the position of women in politics in India, right? And if we are using empirical methods, we are not just relying on those concepts, we are going beyond that, and we are looking at information like this to get a better sense of where do we stand, what is the story on the ground, and why do we need to be talking about law in a different way. All of that is packed into this one graphical representation, and that is why going outside of legal research may, or the legal framework may give us more input. Now, this is not an example, but just for you to think about, right? If you want to do your own empirical research, and I'm continuing the same theme of women in politics, simple ideas can be go to the parliamentary website, and there are different resources for this. Look at the number of women members in parliament. Look at the number of women candidates in an election. And if you compare the two, you'll know that these many women ran for office, these many women actually won, right? So that is again data. So if you're writing about women in politics and it's still a legal paper, you can still include data points like this, and that is still empirical research. You're still going beyond legal research to get all of these numbers, and you have actually done empirical research if you engage in exercises like this. Then you can also look at money raised per candidate and compare it. Have women raised more money than men? What are the numbers telling you? It gives you a much more concrete picture of the situation on the ground. So you can do things like this with the quantitative approach. Next, going to the qualitative approach. This is focused more on discovery. We're not just looking at quantifiable data, we're looking beyond that. So anything that is not numerical data can be considered as the qualitative approach, right? Because we are looking at different ways in which to collect data. We're not just looking at numbers, because numbers may tell you a story, right? And a very good example for this is if we go back. Right. So I was telling you about this graph, right? We can see that Rwanda is doing very well in terms of women in politics, and there are all of these other countries that are doing well, but the numbers only tell you that much. If you were to use more qualitative approaches, right, say ethnography, these are all the methods under the qualitative approach: the narrative approach, phenomenology, grounded theory, case study. And I want to focus on case study here. If you want to take a case study of Rwanda, for example, how did Rwanda get to that level of participation of women in politics, right? Do we want to be like Rwanda, right? And if we do a case study, we get a lot of other input. We are going to be interviewing women on the ground. We're going to be doing focus groups with people in Rwanda and getting their sense of what the situation is like, right? And that gives us a much more holistic picture, because at the end, we will realize that Rwanda didn't get to where they were because of just laws. It was also the social context in which they were situated that led them to be where they were. There was an internal civil war. There were a lot of men who were killed there. And as a result, the women had to take the reins, run for office, win, and actually, govern. So do we want to replicate the same thing? It's not just the law, right? So only the law does not give us that information. Only looking at the numbers does not give us that information. We have to be digging deeper and try to understand what the situation on the ground is. What did women do after the civil war? Right? There were different communities within Rwanda that had different experiences because of the civil war. How did that translate to decision making? Right? All of these things you can really determine if you're looking at the qualitative approach. And another example I think is really relevant here is content analysis. Right? We look at a lot of judgments and we come to conclusions based on that. Right? Content analysis may be a different way of approaching the same thing. And I don't have an example for that here, but I would like to just verbally tell you that say if you involve yourself in an exercise where you're looking at one given scenario, you're looking at domestic violence, for example, right? Now, if you read all the precedents on domestic violence and you come to a conclusion, that is you operating within the legal framework, right? But if you were to look at, say, judgments that were given by women judges on domestic violence, and you try and see if there are patterns in their judgment, and if you're comparing that with judgments given by male judges, right, or judges who identify as men, and if you were to compare that, that is an example of a good content analysis study, because then you're not looking at jurisprudential ideas necessarily. You're trying to look at patterns that are beyond the just the legal framework. You are trying to look at the content of the judgment, and your objective there is different than what it would have been when you're doing a purely legal research. So again, there are ways in which you can kind of meld legal research with these non-doctrinal methods, and you can get a fuller sense of the subject that you're trying to understand or study. So again, I'm going to leave you with another exercise. If you're looking at qualitative research, go on to Twitter, right? There are different websites where you can download Twitter data, and tweets, you may not think of them as data, but tweets are by all means data. They are not quantifiable data, they are qualitative data. So it's not the quantitative approach, it is the qualitative approach. So if you look at 200 tweets, for example, right? 100 that were given by or tweeted by a male politician, and 100 that were tweeted or a politician who identifies as a man versus a politician who identifies as a woman, right? And you look at the responses to those tweets. Of course, you have to do all of these things systematically, but I'm just giving you a general sense of this is how legal research, this is how empirical research can be done. You're looking at the patterns that are there in the tweets itself, right? And you're comparing the two. So again, you're unearthing a layer of the larger research question or the larger topic that we had, women in politics, right? And you're trying to dig at all of these nuances in the approach, in your topic, because then you're not just looking at women in politics in India, for example, right? You're looking at all of these small nuances that exist within the larger topic that you have, and you're trying to unearth more truth or more information through these approaches. So this is another exercise that you can try. But basically, anything that involves non-quantifiable data or anything that does not involve with numbers, you can design research studies around that using the qualitative approach. Lastly, we also have the mixed methods approach, and I wanted to talk about this separately because, again, when I was a law student, I kind of had this idea in my mind that every time you have a combination of doctrinal and non-doctrinal research together, that becomes mixed methods because you have doctrinal and empirical, right? And you're combining the two and you're mixing the two. Now, strictly when we're talking about mixed methods, that is not what it is. Mixed methods is when you're having quantitative and qualitative components. When you're using both the quantitative and qualitative approaches, that is called mixed methods. So then it is still situated within non-doctrinal research, right? So it is not the merging of the doctrinal and the non-doctrinal. It is still within the non-doctrinal field. It is the quantitative and qualitative. That is what you're combining, right? And that is what makes it more holistic. Because on the one hand, you have the numbers. On the other hand, you have these richer sources of data collection so that you can get a better understanding of the subject matter. And you're putting those together and getting a holistic idea of the situation as it exists, right? So that is the mixed methods approach. Now, before we get to that exercise, I want to give an example of a research project that I was involved in when I was a master's student. We had to look at how diverse is the US government, right? The executive branch of the government. So ours was a mixed methods approach. So in the first part of the research project, we looked at federal workforce data, meaning in the executive branch of the US government, what is the gender divide? How many women versus how many men, right? So that is, we were purely relying on numbers there. That was the quantitative element of the study, right? And we were also looking at it on the basis of race and ethnicity. right? How many employees in the US federal government belonging to different races and ethnicities? Okay, and we were looking at it overall, but we were also looking at it from a leadership angle. How many women are there in all versus how many women are in leadership positions? And also how many racial and ethnic minorities are there in all versus how many racial and ethnic minorities are in leadership positions. So there at that stage, we were just looking at the quantitative approach. We were looking at just numbers, right? But that didn't give us a full picture. So then we relied on qualitative approaches. To some of the departments in the government that were doing really well, that had high number of diversity, we reached out to those specific departments and we asked them what they were doing, right? So we asked them what programs were in place. How was it that women and racial minorities in those departments were doing particularly well? And through those interviews, focus groups, we got more data. Remember again, that was a numerical data, that was qualitative data. And through that, we got a better sense of what exactly these departments were doing differently, right? Now, how does this connect to legal research? Because there are several laws and regulations in place that require the departments to have equality, to have diversity. So again, if we were strictly looking at the legal approach, we would have just focused on those laws and said that this is why the laws exist, this is how the laws can be improved, and we would have been operating within that framework. But because we relied on data from the ground, because we looked at the situation as it existed and dug a little bit deeper and got different sources of data, we were able to present a fuller picture and say, okay, this is what the law is supposed to be. These are the provisions in place that ensure that diversity needs to exist, right? But at the same time, this is not how the situation on the ground is. Some people are doing it well, but not everyone. And this is how we can do it better. So if we are presenting our study, then we're not just looking at law, we're looking at the implementation of the law. We're looking at the law as it exists on the ground. And that gives a fuller idea of the situation on the ground. So if we were to make any changes to the law, we know where are the loopholes exactly because we have access to all of this data. And that is a really good example of how you can actually, widen the horizons of legal research by combining all of these methods into that. So expanding the framework, so to say. So again, I'll leave you with an exercise. If you want to think about the impact of women's leadership on policy decisions, I know a lot of people say, why do we need more women in politics? We need more qualified women. We need more qualified leaders, regardless of their gender, etc. Right? So there are specific research studies, and I'm not asking you to actually go and do this research, but there exists research out there where people have relied on numbers, right? So we have reservation at the panchayat level, for example, right? So there have been studies where you have looked at women's representation in specific panchayats, and then they have looked at what the impact has been. Has the situation on the ground really improved as a result, right? And people have actually, or researchers have actually looked at data from the ground to analyze all of these things. Now, why is this relevant in the legal context? Because we are still talking about reservation for women in parliament. And when we do have those discussions going on, then we're not just going to be talking about affirmative action. We're going to present data from the ground and say, we did implement the panchayat level reservations so many years ago, and this has been the impact on the ground. Women have been doing well. We have improved representation. The situation on the ground overall is better, right? Access to health, there is evidence on this. There is an excellent research paper by Chattopadhyay and Duflo from 2004. If you want to go back and read it, they basically, look at panchayats in Rajasthan and West Bengal and come to the conclusion that whenever you have women at the panchayat level, because of the reservation, there has been an increase in public health access for women. There has women's issues such as water, health, etc. All of these have improved in those places, right? So again, we're not just talking in the abstract about whether we need to have women's representation. We are showing evidence from the ground and saying this has been the impact. And we have done this by not just focusing on legal research, but other arenas of research as well. So that is again an example of how you can kind of broaden the horizons of research. Now, I will take just a couple of minutes to go over this because, again, ma'am in the previous presentation has gone through all of these things. So the steps in empirical research are pretty similar to what you have in doctrinal research. Of course, we can go about whether we actually need a hypothesis or we can just have research questions and all of that. But one thing I do want to mention, which I think is really crucial, is that there is a concept called reflexivity, which we kind of take for granted, or we don't really talk about a lot when we look at legal research, which is basically that when we are conducting research, our mind is also not in a vacuum, right? We have our own prejudices, our biases, our judgments that we have that we bring to our research, right? And in a lot of cases, whether it is for a research paper that we write for class or any other situation, we know what conclusion we are going to arrive at before we try to find sources, etc. So we are kind of working backwards. Whereas generally, when you're talking about research, the evidence should lead you to the conclusion. And in a lot of cases, we work our way backwards where we know what conclusion we want, and then we are finding evidence, related to that. And that is sometimes based on our own biases. We know this is how it should be in our mind. And that is why we're like, okay, this is how I'm going to do research. These are the sources I'm going to find, and this is the conclusion I'm going to draw, right? Reflexivity, the concept of reflexivity forces us or encourages us to think about what are our biases when we are conducting research, taking a moment to just think about where do I stand in this research, right? If I am discussing women in politics, for example, I am a woman, I identify as a woman, right? So I may have some biases about my gender that I'm bringing to the research, or I may have some biases about the opposite gender that I'm bringing to my research. And I cannot simply leave that aside and say that's how things are and just move ahead, right? So instead, what you should do, and I highly encourage you to do, any research project that you're doing, take a moment to really think about what is your relationship with the research. If you're writing about an area, right? If you're writing about anything at all under the sun, right? Have you experienced something related to that? Have you had a personal experience that has shaped your thought process? Or do you have any biases that you carry that may be, encouraging you to think about it a certain way? So all of those things are the exercise of reflexivity. How are you positioned vis-a-vis the research? So I encourage you to think about this a little bit, because the last part of our discussion is going to be the significance. And this is what I'm going to be taking the least amount of time on, because I hope that everything that I've covered so far shows you why non-doctrinal research methods are significant, right? So as way of a conclusion, I just want to lay down some takeaways, right? So first of all, what have we learned today? First of all, that if we go beyond the legal framework and if we look at all of these other approaches, we can actually widen the scope of research. We're not limiting ourselves just to what the text says or what the philosophy says. We can actually be looking at much more. So it widens the scope of our research. It actually shows us the applicability of the law. We're not just, again, we're not talking about the law as is. We're talking about what the situation is on the ground. And that matters, right? Because we're looking at the concept of welfare state. We're looking at what the ultimate goal of law is. Why do we have laws in place, and how does that impact the person on the ground? We're forced to look at that. We are forced to focus on the truth. Again, like I mentioned, we're not starting with the conclusion. We are letting all of the evidence lead us to the conclusion, right? And the focus is on finding the truth rather than it's called confirmation bias, right? We are not confirming a bias that we already have. We are actually trying to explore what the situation on the ground may be. And lastly, it's forcing us to be reflexive. It's forcing us to take into account where we position ourselves vis-a-vis the research. What is it about our personal experiences that we are carrying into the research? And are we really letting our biases impact our research? So we are forced to think about all of these things, and that, I think, are some of the biggest takeaways when we are looking about non-doctrinal research methods and trying to see how that employs into legal research. So on one level, we can actually use approaches, but on the other level, we can also think about what is it that people do in non-doctrinal research that we can still take and use in legal research, still use within that particular framework. And I think that is also really crucial. So those, I hope, are some of the takeaways for you today. But that is the end of my presentation. If you have any questions or comments, I've left my email address as well. But if you have anything that you'd like to discuss now, I'll leave the floor open. I think I have about 4 more minutes. So if you have any questions at all or anything else that you'd like for me to discuss, I can stop sharing. Yeah. You can leave any questions that you have in the chat. In terms of sharing the presentation, I will contact your professors and see how that will be possible, but I would be happy to share what I have prepared for today. So any questions, comments, anything that you'd like to discuss in the next 3 or 4 minutes? Are there any softwares to analyze the qualitative data? That's actually a great question because it is something that I struggle with as well. And I will tell you why, because yes, to answer your question, Manish, there are a lot of softwares that help you analyze qualitative data. But a couple of things that you do have to keep in mind are that these are generally expensive. Like the biggest problem with softwares, especially on the qualitative side, are that they are generally expensive. NVivo is a software that I remember. I know that there are at least 2 others, but I can't recall them right now. But if you look for NVivo or NVivo-like softwares, you will find other softwares as well that help you analyze qualitative data. But I do want to mention that I had taken a course on qualitative data. And my professor also had told me that unless you have large quantities of data, qualitative data you can generally do by yourself. And that is the experience that I have had as well. So unless you're dealing with, say, hundreds and hundreds of responses, qualitative data is something that you can manually do as well. I know it becomes cumbersome to really read through all of the responses and all of that. So just for the analysis part, to answer your question, yes, there are softwares, but they are expensive. Currently in my work, we are doing focus groups and interviews, and I think we have close to some 30 odd responses, and we haven't thought about having any kind of software for the analysis. A, because we're a small nonprofit and we don't have the kind of money to really think about softwares. But also, I think for qualitative research, especially because it is so immersive, it really helps if you're manually doing it. And I don't think maybe that's just me saying that because these softwares are expensive, but you can definitely do that manually, and that should be fine unless you're doing some mega project. But one other thing I do want to mention about qualitative data is, even though for analysis you may not have specific softwares that are accessible, you do have a lot of what are they called? Speech to text softwares. So if you are recording your interviews or focus groups, you have free softwares online. Sometimes the trial offers, you can use those as well, which basically help you transcribe your data. So all of the recordings that you have, you will automatically get that in Word format, and you don't have to sit and listen to like endless hours of interviews and focus groups. It will do that at a click of a button, and that at least makes your job easier. And like I mentioned, those are cheaper, and sometimes you can get the free versions online and you don't necessarily have to pay for them, unlike the actual analysis softwares. So I hope that's helpful. Any other questions or comments? I have like 1 minute.
Thank you so much, ma'am, for your session. As we can see in chat box also, like everyone loved your session. In such a short span of time, you have explained such briefly and nicely all the concepts and terms. Really, thank you so much, ma'am.
Thank you so much, and thank you for inviting me as well.
Thank you, ma'am. With your permission, I would like to conclude this session by proposing the vote of thanks. Firstly, I would like to thank respected Dr. Vasundhara Kamath for giving her time and upgrading her knowledge, which surely be helpful throughout our lifetime. Also, I would like to extend my big thanks to our respected Principal C.M. Rao, sir, for always making available such opportunities and situations to us. Vice Principal Shri Krishna More, sir, IQAC Coordinator Dr. Aparna Kottapalli, ma'am, for brilliantly coordinating this session and workshop. Professor Pratibha Girbane, ma'am, for the welcome address, and also a big thank to the management team, technical and non-technical staff, and also participant for showing such interest and listening this session with patience. Thank you so much, all of you. Here I would like to request Aishwarya to continue with the further session. Thank you, ma'am.
Thank you, Vasundhara ma'am.
Thank you, ma'am, for inviting me.
Welcome, Akash.
Thank you very much, sir. Good afternoon, sir.
Good afternoon.
Thank you very much, sir, for calling me for this talk on a very relevant topic today.
Okay. So 2 minutes, the other people are joining.
Sure, sir.
Aishwarya?
Yes, ma'am, yes. First of all, a very good afternoon to our respected principal, Dr. C.M. Rao, sir, our vice principal, More, sir, IQAC coordinator and subject teacher, Dr. Aparna Kotapalle, ma'am, our subject teacher, Dr. Amol Chavan, sir, all the teaching and the non-teaching staff and the participants. I, Aishwarya Deshpande, am here to proceed with the third session of one-day online capacity building workshop on research and methodology. And I would like to request Dr. Anju Singh, ma'am, to present the welcome address before all of us. Over to you, ma'am.
Respected resource person, respected principal sir, vice principal, IQAC coordinator, and all attendees. I welcome you all in the third session of one-day online capacity building workshop on research methodology. And in the previous sessions, you have all witnessed the lectures of resource persons on the topic overview of research methodology, doctrinal research, significance of non-doctrinal research. So I would like to inform you that the theme of this session is jury metrics and legal research program, Lexis and Westlaw coding. And to guide us on this theme, we have with us Dr. Akash Singh, Assistant Librarian, Delhi National Law School. And on behalf of MP Law College family, I heartily welcome you, sir. And I also thank you, sir, for gracing the occasion as resource person. Thank you, organizers, for giving me this opportunity. Over to Aishwarya.
Aishwarya.
Yes, sir, yes, sir. Thank you, ma'am. To do successful research, you don't need to know everything. It is greatly said by Arthur Shollo. Today, for this thing that isn't known to us, we have with us an eminent personality, Dr. Akash Singh, sir. It gives me immense pleasure to introduce Sir, who has bundles of achievements and is a great example of perfection. So talking about Sir, he is working as an assistant librarian with National Law University since October 2009. Prior to his present assignment, Sir has worked with Indian Law Institute Kendra Vidyalaya and IITM Delhi. Sir has obtained his bachelor's from Delhi University, MA in Public Administration, LLB from Meerut University, MPhil in Library and Information Sciences, and postgraduate diploma in Library Automation and Networking from Delhi University. Sir has obtained his doctorate from Vikram University, which is in Ujjain. He has also qualified UGC NET 3 times. He has credited 14 edited books and 33 articles in peer-reviewed journals and conferences. He was a member of Team's implementation of digital library initiations and digitization of the Journal of Indian Law Institute and the Annual Survey of Indian Law. He is a member of various library associations. Sir has also been awarded the Best Young Law Librarian Award and many more such awards. I feel grateful to have such a great personality with us today. Sir would be dealing with the topic jury metrics and legal research programs, Lexis and Westlaw coding. So before proceeding ahead, I would like to request all the participants to keep the mics and videos off for better functioning of the session. Now, on behalf of Marathwada Legal and General Education Society's Manikchand Pahade Law College, Aurangabad, I heartily welcome you, sir.
Thank you, Ishwaraji. Thank you, Anju ma'am. First of all, a very good afternoon to all connected academicians, law practitioners, and dear students. At the first, this is my duty to thanks Dr. Rao sir, Principal MP Law College, for inviting me to talk on a very relevant topic, which is actually very important for legal research programs. And I'll extend also my sincere thanks to the other respected dignitaries, the Vice Chancellor, as the Vice Principal of the college. I can't know the name of the sir, but and the IQAC members who organize this program. And obviously, this is also important to extend sincere gratitude when you are starting your sharing the dice with big legal luminaries like Dr. T.V. Subbarao sir, Professor Emeritus, and Professor Sumitra, Madam Principal, College of Law, and Professor at NLU Delhi, Dr. Jeet Singh Man sir, and Dr. Vasudha Kamant. And I should say that it would be honor for me to deliver a talk with such a big legal luminaries. Since morning, we are actually learning and listening about the juris metrics, and now this is my turn to add the way of search, legal information, and data out of the source of universe of knowledge. You know, if we talk about the law in general, law is actually nothing but union of information and power. So if you have the union of information and you have power, it means you are the main expert in law. And this is also true that ignorance of law is no excuse, and this is not for only the general public. This is also applicable for the legal researchers, academicians, and the practitioners. If we actually talk about the legal information, you personally will feel the quantum of legal information we are encountering nowadays as compared to previous decades. So before going forward for my talk, I just want to share my screen.
Just a moment, sir.
I just want to confirm whether my screen is visible to all.
Yes, yes, it is visible.
So we were discussing about the quantum of legal information, and if I think all of you are agree that now we are in an information age, and in this age, legal professionals basically we have to rely more and more on database and the information retrieval process, not only for the legal research, but all such the electronic information pattern we have to use for manage the litigation documents, for the client files, and for the calendaring systems. And obviously, when we go for searching legal information, we should have well-versed skill to handle digital information as well. So my dear students, now we will discuss the current trend in doing electronic legal research. As a law academicians or practitioners, we should have a basic overview about the source of primary legal information. So when we start legal research, we should have basically we should have a preliminary we should have a knowledge about the type of legal information, what we call them as a legal basic pillar of legal research. Like as the screen is self-explanatory, that when we are doing any empirical research or doctoral research or any type of research we are doing in legal field, we should have a sound knowledge of a number of documents which supports your legal research. Like first one is as I have mentioned, the constitutional documents, which includes the constitutions not only in India. When you are doing any comparative law, you can be requiring the constitutions of the other countries too. So apart from the constitution, you will also be in need of using the documents pertaining to constitutional developments of the state. Some constitutional amendment documents will also be needing. Apart from that, parliamentary debates, which are actually the recorded discussions for during framing law in parliament or legislative assemblies. Actually, these are very important when you are doing legal research. Apart from that, the legislation framed by the parliamentarians, these are also considered as the most useful information for when you are doing the legal research. Apart from that, case laws and case laws, the precedents or any other rich form of source which are to be considered as the useful. Actually, the case law, they are considered as very useful for routine research and practices by lawyers and academicians. So these are also considered as the very important source when you are doing research, your legal research. Apart from that, law journals and scholarships are there, treaties are there. So we can say from the legal education to practicing lawyers, you will always be needing all type of information, as I have shown to you during your course of work. And I must say that with the advancement of technology, all the sources are now in the reach by a single click of rat. I'm using the word rat instead of mouse. So and obviously, as today we are living in the IT age, so computer based databases, when you are doing your research, can be searched in a second, and rather than the hours that a traditional search can take. So when you are using the computer based databases for your research, it will be very useful for you, and it can save your time. But the question is here is that whether you know the search techniques or the search queries which is required for searching all the informations which is related to your sphere. Of course, every technology, actually, it has a drawback, as we are now in living in the IT age. And still, when you are using IT, there may be some drawback. If you do not ask just the right questions to the computer database, search can written too much information. Like if you will do Google for a term, you can get a millions and billions of results. But it is basically the art when you are searching something for your research topics, how you are formulating your search query. So all such things are actually can be actually taken out with the help of a searching arts among a number of e-learning modules available. Like nowadays we have the e-books, journals, databases, we have tutorial lectures, we have online training programs, and we have a number of search engines. And apart from that, we also have the open source websites, and social networking sites are also there. So there is one question stands. Basically, how to ask the right questions of the right databases so that you can do effective legal research. This is a big question when we start our research for researching anything. We should have a good knowledge. We should have a sound knowledge to which database we have to approach for getting this information. So apart from that, you should also aware about the basic search techniques when you are searching anything from the computer based database. Apart from that, I already explained that we should have the sound knowledge of effective search techniques, query formation techniques, others, when we are using the computer based databases for our research. So I would like to show you some general techniques. Like when you are doing open research, whether in Google or any other search engines, you can use the logical Boolean operators. As you know, the Boolean operators, it is a very common term since our I must say from the very when we start the computer education. So we the people those who are just studying, those who are teaching us about the search engine techniques, so they inform us that and or notes are the basic Boolean operators when you go for the open search in any open Google environment. So these are the very important terms, and you can use these Boolean search operators for concise your research. Apart from that, some other apart from the and or not, there is a number of other logical Boolean operators are there, like phrase searching operators are there. Like if you just want to search anything within the phrase, so you can put the inverted commas and you can keep them close. This is a very general things that everybody knows and everybody is using. If you are acquainted with the Google search. So but apart from that, if you are if you just want to extend, or if you want to search the other Boolean operators, a number of other Boolean operators are also there. We call them that the proximity operators. So if you want to search anything from a particular paragraph, so from searching this paragraph, you can keep you can use the search \p as an operator, and the \p operator indicates that you would like to locate documents containing 2 or more keywords within the same paragraph. So like if you just want to search the constitutional right property, in this case, like you can put your search as constitutional right, and you can use the \p and property. So apart from this, we also have 3 another proximity operators. Like if you want to search within a search, you can use the \s. If you want to search about a number, it means like if you want to search within 5 or 10 words, you want to search that whether these 2 terms have been used or not, you can use the \n number proximity operator. Apart from that, when you do Google search, when you do simple Google search, you can get an n number of responses. So for when you do the Google search, you can go for the Google Advanced Search for concise your research, and from Google Advanced Search you can actually concise your search, that you can concise that from where from what type of content, like the most of the research articles you will be find that they are available in the PDF format. So you can change the format of that particular document you are searching for. You can also change the timeline that after you need the documents after 2000, or you need the latest articles published in 2021. So all such things you can do by yourself in the simple Google Advanced Search. So those who have not yet used the Google Advanced Search, so this is very easy. You can open the Google document and you can go for the Google Advanced Search, and after that you will be redirecting to the Google Advanced Search option. I think more than 45 options are there, so you can select these options for you. Apart from that, when you are doing research on a particular topic, like the respected speaker, she was delivering lecture on women and the politics in India. So in this case, if somebody is doing research on a particular topic, you can actually form a Google alert for your research. So when you do the Google alert, it's a very simple. You have to type the Google alert in a Google window, and it will open this alert function, and you have to basically put the keyword, and your email ID must be there. So every day you can also monitor this Google alert, that at what time you need the alert. So whatever is publishing in almost all around the world, you will get in the if you are setting it that you will be needing it by morning 5 a.m. So you will get all the relevant information or the relevant the alert of the topic, whatever you are doing research promptly and on daily basis from the open search. So my dear friends, till this time I explained you how you can concise your search and research with the help of a number of operators and the techniques. Now as now we are living in ICT era, and we have an age to have various types of databases with us. And today as we have commercial supported databases, we have, like you as you are the law students, you have listened a number of about the legal information databases, and apart from that, a number of public domain information databases are also exist. And today's presentation, in the first part of this session, we will discuss about the major commercial databases, and in second part we will learn to grab legal information in absence of such commercial databases accessible in academic institutions. So now I would try my best to highlight essential features of commercial databases, so that you could be able to reach to best suited database to grab your needed information when you are doing research. So as I have already explained you that now we will discuss about the commercial databases, and commercial databases actually are famous for doing legal research now due to a number of features. Like commercial databases, they have a good coverage of legal information, and these databases actually have a good embedded, a good search efficiency, and they can provide the federated search results. Apart from them, commercial databases, why we use it, because they provide the standard facilities and authentic information. And obviously these databases have their representatives, and they provide trainings and other support facility. So now we are going to discuss few important electronic databases in next part. So first of all, we will have a look on the various type of databases which are generally used in the legal information and research. So I have bifurcated all the databases in two parts. First one is the international commercial database. Second is the Indian commercial databases. So if we'll talk about the international commercial databases, actually n number of databases are available, but I have mentioned here the most used and the comprehensive databases which are generally and which are popularly used in the legal research. So if we'll talk about the international commercial databases, LexisNexis has its age, and apart from that, Westlaw is a very good database. Apart from that, if you want to access the, if you want to get the scholarships, means the research articles and research findings for your doctoral or for your postgraduate research, or rather if you are doing your you are preparing your project report for LLB semesters. So JSTARS and Hen Online are very good databases. So today we will discuss two Indian commercial databases. One is the Manupatra and second one is the SSC. So if we will start with the acquaintance of SSC. Actually, SSC Online is now it's available in the web edition. Previously, it was available in the server-based or the CD-based database, but now it is available on the web edition, and it contains the access of the Indian case laws, and you will be able to find all the Supreme Court, High Courts, and tribunals and few district court judgments in it. One more thing I just want to share about the SSC Online. SSC Online is the only database which provides you true copy of the print SSC journal. So the printout of the SSC is admissible in the apex court or the high courts in India. So that this database is considered as the most authentic database in India. So apart from that, this database also provides the Indian statutory laws. If you need any law related to central government, state government, even the statutory subordinate legislation you need. Apart from that, regulations are also available in it. Apart from that, it also provides a number of Indian secondary materials. So we'll discuss it as next slides. So the search is very easy. When you log in the SSC Online, you will see that there is a blue color of tabs, which actually is the sign of the primary resources. You want to search anything, you can search the word search, the single word search you can do. You can find case law by section. If a particular section you have with you, you can access the case law or the articles or the legislation with the help of citation you have. You can also access the case by the name of party name, and you can also if you have a particular topic, you can also search the SSC Online with the help of that topic. Apart from that, it also has a good feature, word and phrases. When as and when you are doing your research, you will be needing the technical or I must say some legal explanation of a particular term. So this is a very useful database for the researchers. Like if you need the definition of autonomy, or you need the definition of euthanasia, any term, so you can use the word and phrase point. And if the Honorable Supreme Court or High Court, they have elaborated that particular term you need, so the complete elaboration and complete explanation with the name or with the citation of the judgment you will get from it. So the second part is the browsing, the red part. It is the actually the browsing facility this database has given. So you can browse the research outcomes on the basis of the topic. Apart from that, you can browse the law reports, you can browse the judgments by courts or the tribunals, you can browse the acts, rules, and actually SSC print volume, it contains the articles too from contributed by the legal numeraries. So all the articles since 1969 you can access with the help of this database. Apart from that, a number of secondary materials are also there. You can access the treaty, you can access the moot court resources. If you are planning or you are doing something, you are contesting for the moot court resources. In this case, this is also a very good platform for managing or creating or writing the moot memorials. Apart from that, you can also access the legal business news from this database. So the third link is the blank link, which is actually the SSC blogs. Blogs in the sense ki you can access the international material with the help of these tabs. So actually SSC, if you are accessing the international the comprehensive module, so you will also get to access the LawNet database, which provides the access of the Singapore law. Apart from that, HinOnline is also embedded in it if you are if your institution are subscribing in it. Apart from that, it also provides SSC online blogs and EBC Learning, EBC Web Store, and SSC online stores. So apart from that, as I already explained you, that it contains the judgments, and you will see that you can access, if you need the judgments of the federal court, you can access from it. Apart from that, Law Weekly, Madras Weekly, ILR series from the Bombay, Lahore, Calcutta Weekly, notes, pre-independent series are also available with the help of this database. Apart from the federal court, you can also access the judgments of Privy Council with the help of SSC online. Apart from that, some historical courts, if you are searching for, you are doing research on any topic on which pronouncement was made during by any historical court. So in this case, historical courts like Ajmer Judicial Commercial Courts, Goa Judicial Commissioners Courts, and Sindh Judicial Commercial Courts, a number of courts are available. The judgments of these courts are available with it. Apart from that, I have already explained you that Indian statutory laws like primary and secondary legislation you can access with the help of this SSC online database. So the another important thing this SSC online actually provide is the secondary material like Constitutional Assembly debates are also available. Apart from that, the commission and committee reports like Law Commission of India reports, Human Rights Commission reports, you can access from this database very easily. Legal article and historical trials are also available in it. Like, you know, right now 75 years of independence Amrut Bharat Ka Mahotsav is working on. So you can access the historical trial if you are writing something for this for celebrating or for writing for this Amrut Mahotsav of India. Apart from that, Tagore Law lectures. So Tagore Law lecture series are also available in it. So Tagore Law lecture books are not available in print format in anywhere. If you are reading any articles and you need to refer any Tagore Law lecture series book, so this is the right source to approach. So this was the SSC online. Now we have the another, actually the in India. On the Indian part, we have the another software, we call it Manupatra. Actually, Manupatra contains the same things whatever the SSC contains, but SSC, but the Manupatra has a good navigation or the search techniques within it, as it is showing that it is providing the Supreme Court judgments since 1950. Apart from that, it also provides various courts judgment like Allahabad 1875 to till current, and it covers almost all the high courts and the tribunals and the commission's decisions. So this is also the parallel database for searching the cases as compared to SSC. Apart from that, Manupatra is also well known for getting the bills in parliaments and audience, which you can also accessible with SSC online, but the formation and the easiness on the navigation you will find in Manupatra is more useful in this database. So apart from that, notification and circulars on the basis of various subjects, you can also click. Like you are doing research on law and justice, or you are doing research on labor law, you have to simply click on labor, and you will get all the notification and circulation of law ministry, labor ministry, or any other part of India, any other government of India, the state government of India. So and you can get a complete comprehensive list at a single place. So apart from that, Manupatra is also having secondary material, like if you need any commentaries on the civil procedure, criminal procedure, Company Act, Constitution of India, and a number of topics are there. So this database also contains a few commentaries which are updated time to time. So you will be needing to go to the secondary material, and you can access the the commentaries and few ebooks available in soft copy in it. Apart from that, it also provides the dictionaries like veteran law lexicon. It contains universals law dictionary. Manupatra also maintain its own law lexicon. Apart from that, English Hindi dictionary are also there. So now actually we have a 1 hour only, and I have to show you a number of things. So I just take your permission to do with a speed. So the next is now we are entering to the international database. So when you are doing research, and you need articles in your subject field on which topic, on the topic you are doing your research. So Hen Online is a good database. Hen Online is considered as the international database. And the beauty of this database is that that when you are you just want to get some comparative international material, you can visit to the Law Journal Library, and you will be able to access more than 2500 law reviews around the world. And you will get all the latest information from all around the world, which will be very useful for you. And the second beauty of this database is that it contains the legal classic books. Legal classics are those books which actually was published in around 1600, 1700, and most probably before 1950. So these books are not available now in print format. And law is the ongoing process, and when you are doing research on a topic, and you need some niche research research material on your particular topic, and your topic is actually the genesis of your topic is actually very old. So in this case, you can get the legal classic books support with the help of this database. So apart from that, JSTOR is another international database. Actually, when you are doing multidisciplinary research, and this is not only pertaining to the law. It is you may be doing research on medicine and law, or you can be research on physical psychology of criminals. So if you are doing research, the multidisciplinary research, so these JSTOR is very useful, because it doesn't contain only the information relating to law, or the legal information, or from the legal institutions only. It also provides the comprehensive and comparative information from other field too. Like JSTOR, basically you can access the content from history, humanities, law, medicine, and allied health, area study, art, business, economic, science and mathematics, social sciences, and lots more. And one more thing, it also provide access of more than 3000 ebooks published by the universities, by the press related attached with the universities all over world. So like if some publishers, the commercial publisher is publishing its book, so you can purchase it. But if some university is publishing any book, so in this case you will not be able to get the copy of that book. So this type of books which published by the university publication, university authorities all around of the world, you can access from this JSTOR application, JSTOR database. So now the good database which helps us for the legal research is the Westlaw Asia. Actually, Westlaw has a long journey. Initially, it was the Westlaw Academics, and it was providing information of only the international jurisdiction. After that, it was converted to Westlaw Asia, and it was actually the the main index page was actually shown as that it is a Indian product. But now they have again the Westlaw people, they have changed it as Westlaw Asia. And if you will see, they have the home page, they have arranged it like they on the basis of the content. You can access the cases of a number of countries. It has already mentioned on the screen, like if you want to access the cases of Australia, Cambodia, Hong Kong, India, Indonesia, Korea, Malaysia, Myanmar, and the United States, you can use this term. And this is also very good and very easy to navigate program. Like if you just want to search case on a particular topic, and you just want to do a comparative study among the cases of two countries, so this is a good database for doing your research. So apart from that, again, this is the vice versa platform they provide, like jurisdiction wise platform. Like if you just want to search the material of India only, you can click on the India and you can search the cases from the Indian jurisdiction. So if you want to search the other international material, you can go for the Westlaw Classic. So Westlaw Classic is basically a very good search engine for it supports basically the secondary sources. And if you will see, a number of documents are there, the secondary sources are there, which are very useful, and which if you are doing the advanced legal research and you just want to do the international comparative law research, so these tools are very useful for you. So if you will click on the secondary sources, you will see it contains the various dictionaries. It provides access to the current index to legal periodicals. It provides the international materials, law reviews, and apart from that, legal resource index, and a number of other secondary source information. So the next or the last in the commercial segment is the Lexis Advance. Actually, Lexis Advance, it also has a long journey. Initially, it was Lexis Nexus Academy. Now they have come up with the Lexis Advance India option. They have included Indian content too for grabbing the market in India. But this is a very good database in if you'll think that you want to search or you want to get the fast or the prompt results, because it has a good navigation main index page. So this is basically the page you have to type your search in the top of the box, and you can also change, like this is the static. I can't show you the change. Like if you are noticing at the top of the left, Indian flag is showing. So you can click on that arrow, drop down arrow will come, and from there you can choose the country for which you want to select you want to get the information. So you have to select that particular country. So this is a very simple one box search engine. So now we will discuss that what Lexis Nexus Advance has. If you will see the Lexis Nexus India, it contains the Supreme Court judgment, and they claims that they have more than 2.4 million Indian cases. And apart from that, from the Supreme Court, they also have the access of the various high court cases, and they also provide central acts of India. Each and of us knows that the bare acts from the Universal Law Publishing. So now Universal Law Publishing bare acts are available with the Lexis Nexus Advance, and they are being updated time to time. And so if you don't have access of the latest bare act, if you don't have the access of the you don't have the print copy of latest bare act, you can visit to Lexis Advance India, and from there you can refer the Universal bare act very easily. Apart from that, the beauty of this Lexis Advance India is also there, that if you want to access the commentaries, like universal if you want to access the encyclopedia and forms and precedents, if you want to access the Halsbury Laws of England, if you wanted to know to access the Atkins code forms, actually these all reference books are very costly. And when a library plans to purchase the set of like I am giving example of Halsbury's Laws of England, you have to spend I think around 10 to 15 lakhs. So if you are you have the access of the Lexis Advance, you need not to be worry that your library is not subscribing such highly rated encyclopedias. You can go to the Lexis Advance India and you can access such reference books. Apart from that, I just want to explain you, like the DD Basu commentaries on constitutional law and the Mullah Hindu law. These all are very important and regular commentaries which are used by the law students and the law researchers. So I think more than 170 commentaries of the same standards are available with the LexisNexis. And you need not to wait for the next publication to be procured by your library. If you have the access of Lexis Advance, you can have the benefit of such books with it from in it. Apart from that, as I have already explained you, the analytical material and like analytical materials are the same, the reference books and the commentaries available in it. Apart from that, you can also have the access of the Australian, if you are accessing the Lexis databases, and you can also access the Canadian legal information, and the US contents are also available in it. You can access the UK cases, UK legislation, secondary materials, forms and precedents, and apart from that, news and index and tables and regulatories are also available. And I just want to share one thing with you, that whenever I get a reference from my authorities or from any court regarding the newspaper clippings for a particular topic. So Lexis Advance has a good feature, and it contains almost all the newspapers published all over the world, and you can select the India. If you need the information about or the newspaper clipping on a topic from the Indian newspaper, you can select the particular newspaper, and you can search your search term, and you can also concise your search on the basis of the time frame for which you need the news articles you need for that. Apart from that, you can also access the Hong Kong materials. So my dear friend, I explained you about 6 journal databases which are very much in use. But problem is that there is a financial constraint when the most of the databases it contains heavy cost. Like if you are going to procure all such database, you have your library or your institution, they have to pay I think more than 25 to 30 lakh rupees per annum. And apart from that, some as you know, India has more than 2500 law colleges, and there is actually the geographical disparities are there, and a number of facilities are also lacking at the part.
Dr. Singh, sir, you are not audible. Dr. Akash, you are not audible. Please check the connectivity, sir. It is very fabulous session that is going on.
Respected Akash sir, we are unable to hear you, sir.
Legal Institute was set up. So the World Legal Information Institute, actually this is the main virtual law library which provides the actually indexing of the all the legal information available around the world. So in this screenshot you will be observing that this World Legal Information Institute, as it was last updated today, the 1st September 2020, it contains more than 1,834 databases from the 123 jurisdiction around the world. So if you want to access the information of a particular country, you can click on all country on the left hand side. You can access the information of all database. You can access the information of all region, and a number of options are available in this database. So these are the lists. I just want to share one information with you that in I think 6 or 7 years back, one Chinese delegate they visited National University Delhi, and they were saying that we are very much close and we don't share too much information to rest of the world. So at that time we actually we had already planned to show you some Chinese things what we have and what we contains with us. And so when we showed them about the worldly and we showed them about the China information, they were very much surprised that they were not assuming that such type of information may be out. So I just informed you about this story because that if you can't imagine that how type of what extent of information you can access with the help of World Legal Information, and obviously this information is free of cost. So this is the regional table of the which region information you can access with the help of these databases. These are the actually logos of the member LIIs. Basically these are the websites, the legal information websites of particular country or a particular region. And when you will visit the worldli.org, you will find the these logos, and you can click on that particular logo for getting the information of particular country. So this is the Legal Information Institute of India, and you will observing that it was also the last updated on 1st September 2021. And if you'll see that it is showing that all India reporter of 1907 to 1948 and other law AIRs published before 1950s are available to access in it. And you will notice that the judgments, basically this is the main page, front page, and it shows the alerts. The judgments of 11th August 2020, it was actually made, it was delivered on 11th August, and it is showing in the front page of this database. So if you'll talk about the LI of India, it provide access of 1834 database, and it may be search simultaneously. Like if you want to search on a particular topic, you can search the case laws and the articles and the judgment and the legislation and the committee reports at a single time. So this is a very powerful system, and its result can be ranked by relevance, date, and citations, and all the text is actually hyperlinked. If you are reading some articles, and if you notice that there is a judgments they have quoted in the text, so the judgment is hyperlinked with the full text judgments. Apart from that, law site citators are also there. When you will visit the LI of India, you will get acquainted with this database easily. So this is the coverage. Basically people provide access of the central government acts, and these all information are free and from the authentic resources. And you will notice that they also provide the true copy of a number of legal information. Like if you are accessing the state laws, you will find the copy of the gazettes. And apart from that, if you are searching for some law commission of India, any reform commission reports of any reform commissions, so you will find the true copy of that particular options. So this was the one initiative, but a number of other initiatives are also there, and you can also take benefit with the help of these databases. So I think I have 10 or 15 minutes more, and I'll try to conclude my talk in next 15 minutes. So like I already explained you that there is a number of pillar of legal education. Like if you just want to do your research, you have to you will be need to get the information based on such pillars. First of all, I'll be happy to inform you that if you want any case, case or case law from the Supreme Court or the High Courts, or you just want to know the status of any case, or you want to know the any course, so you can visit to the services.ecourts.gov.in. So this is the actually website which is very useful when you are doing research and you are not you are not having any access of the commercial database, and you need any judgments on a particular topic, or you need a judgments on the basis of the party name you have or the case number you have with you. So this website, it provides the access of a number of things, like you can access the e-committee reports, you can access the Supreme Court judgment, you can access the High Court judgment, you can access the district court judgment, you can also know the national data grid and judicial data grid, and and number of information. This is the screenshot of the Supreme Court search engine you can access with very easily with the help of these websites. And this is basically the e-court services from where you can access the cases of the various high courts of India. And you will be noticing that if you need to access the judgment of various district courts of India, you can also take benefit of this website. So this is the National Judicial Data Grid. So this actually shows the pendency of the cases, and the how much cases have been finalized and how much is pending, and on the basis of the nature of the cases. So this is when you are doing research on the data or the statistics on a particular case, you can use it. And you can also find the pendency or the finalization of the case on the basis of the states and the districts too. So this is very useful for the legal researchers who are doing research for getting the information about the court case status around India. So now, apart from that, we talked about the Indian cases, but if you need to access about the foreign apex court case law, so there is a number of websites from there you can get it very easily. Like you need not to subscribe Westlaw for or the LexisNexis. If you don't have the access of the LexisNexis and Westlaw, you can also you don't feel that you are lacking behind. You have a number of other sources from there you can get the information. Like if you want to get the Supreme judgments of the Canadian Supreme Court cases, Supreme Court cases. So since 1877, you can access all the information, all the case laws published by the Supreme Court. And they people provide the true official report copy, and you need not to worry that whether this is authenticate or not. They provide exact PDF copy of the case law published by them. Actually, Supreme Court of Canada, they people published their official Supreme Court of Canada report in the name of Dominion Law Reporter, and you will get the complete same copy of the same on this website. So apart from that, the Australian High Court judgments from 1908 is available, and they provide a good search mechanism, and on a particular topic or on the basis of the party name, you can access such judgment. So apart from that, UK Supreme Court judgments after 2009, as the Supreme Court of UK was established in 2009, so the all judgments are available with the Supreme Court of UK Supreme Court of Judgment website. So apart from that, if you need to access the House of Lords judgments, so BAILII, as I explained you already, the word Legal Information Institute, this is BAILII is the actually family member of the World Legal Information Institute, and you can access the judgment of House of Lords since 1709 to 2009 up to that when the UK Supreme Court started function. So apart from that, if you need any case reference from the International Court of Justice, the all cases are available in the exact report format, and you can access with the help of this. So apart from that, if you need the judgment of the Court of Justice of European Union, these judgments are also available. So the another important important information, legal information you will be needing is the legislative resources like parliamentary resources, constitutional documents, and legislation. So all such type of legislative resources are available under public domain, and you need not to worry that you don't have access of the commercial databases. You can go and you can search these resources very easily. So if you need the parliamentary debates of India, the Lok Sabha and Rajya Sabha, since 1996, all the debates are available, and the government is under actual process to digitize all the debates, and I think most probably up to next year, the all debates since 1950 will be uploaded on the website. So apart from that, if you are if you need constitution of any country, this is a very good data. Constitute is a very good database, and you can also compare two constitution on the basis of a number of things. As we have a limited time, so I can't show you, but I request you all, you should at least use this database when you just want to search the constitution of any country. And this open access database provide the access of the constitution with the updated version of each and every country, and you can also compare 2 or 3 constitution at a single window with the help of this tool. So apart from that, if you need the Indian legislation, you can go for the India Code. India Code is a very good digital repository for all central and state act, and the Indian government, they have tried to provide the exact PDF copy of the official legislation passed by the parliament or the legislative government. Apart from that, if you need any analytical document on any legislation, you can go for the PRS legislative research, and you can get all the relevant document like the bill for that particular act. If there is any committee, you can also get the text of that committee too, and you can also get the analytical views and the comments of the experts on that particular bill or the acts. If you're doing if you need any the advanced content or the content of the any particular legislation, you should visit the PRS India. So apart from that, if you will talk about the legislation, the Australian legislations are also available. You can access with the help of the website. Apart from that, legislation from Canada is also available at the Justice Laws websites. And as you know, the Britishers were in India. So if you will be needing to refer some the British India Times law, so at the for the previous time laws, you can access to the United Kingdom's legislation websites, which we know as legislation.gov.uk, and this websites provide access the authentic copy of Public General Act since 1267 to present till date. Apart from that, US code is also available. All the previous codes and the latest codes you can access with a single click of mouse with the help of the United States legislation website. So I am just skipping all the things very fast, so because I will show you that you need not to write the URLs or the name of such things, because we have made one mechanism so that you can get all the information from a single web page. Apart from that, I explained you about Hin Online and the JSTOR, from where you can get the scholarships and the law review. So a number of open source portals are also there. Like if you will see, the law review commons are there. You know, the most of the law schools in USA, UK, and Europe, they actually have an agreement with each other that they will not they will publish their law review in open access. So this is basically a single platform from where you can access such 300 open access law reviews from a single place, and you can access more than 2 lakh articles from this particular website. So the same journals, whatever are available in JSTOR or available in Hin Online, you can get access from this resource. Apart from SSR and Social Science Research Network is a very good database from which you can access more than I think 9 lakh articles submitted by the authors generously. So so this is a good database. You can take the service of this SSRN for keeping your all the research articles at a single place, and you can also access the submissions of others from this database. Apart from that directory of open access journals are also there and provides access of more than 14,000 journals. So when you have sound open access tools to access journals for your research, so I think you should not think that you are actually you should not feel underprivileged that you are not have access of the commercial databases which are very tough. So like we most of us, we like to go for the Google search for a number of academic searches. So I suggest you all, you should instead of go to Google, you should go to the core. Core is actually the I must say a parallel search engine which will not give you the unwanted searches, because actually as you are seeing that it contains a good number of full text articles and a number of reads and the textbooks and the papers. So such paper, it will give you the only the authentic and the good research, authentic research, for which can be you can use directly with your research. So Journey is the another search engine you can also use for your academic research, and it contains actually access of more than 3,000 journals from the social science sphere. You can access the law, a good quantity of the journals from the law sphere. Apart from that, OER Commons are also there, and this platform can be accessed with the if you just want to access a few case studies, data sets, you want to access the primary sources, you want to access the lesson plans. So all such things you can access with the help of a single platform. Apart from that, you can access the Indian treaties if you are doing some the comparative research with the relations of India with another countries. You can access the treaties. This is the good good portal by the Ministry of External Affairs, which provide access of the treaties with Indian. If you just want to access the international treaties, so the United Nations treaty collections are also there. The complete set is available for in print around 24 to 25 lakh, but the complete set is available free of cost, and you can access this set free of cost in searchable format with the help of this website. So apart from that, my dear friends, I think this is the last segment. You can the international publishers like Springer's, Bloomsbury, OUP, and a number of publishers are also there. Routledge are also there, and they people provide, actually they people publish book and they sell book at a very high cost. But after the introduction of the open access initiatives, these database peoples, these commercial peoples, these publishers, they have started publishing the books in open access under gold open access. So the quality books, they also they are also providing for access from their database. I have done a research. You will see that more than 60,000 standard ebooks published by renowned publishers are available under open access with the help of these their platforms. So this is the matter, that when you want to access the books from the standard publishers, you can visit to their the ebook portal, and you can access, you can choose, you can select the open access book only, and you can enjoy the certain row of the authors, but they have submitted to these commercial players for the open public. So apart from that, if you want to access the ancient materials or the copyright materials, a number of databases, a number of open access databases are there, like Internet Archives are there, Project Gutenbergs are there, open libraries are there, the National Academic Press is there, Digital Book Index is there, directory of open access books are there, with the from which you can help more than books 2,170 open books from the 70 publishers. Apart from that, a number of other databases are also there. Apart from that, law reform reports are also available with the help of and you can access the reports of such commissions and committees very easily. So I just request you all, if you want to access all such information from a single platform, you can visit to these two websites. These are the public domain resources.webs.com, which provides actually information related to legal content only. Basically, we have indexed all the open access resources or the public domain resources I explained in my slide in a very exhaustive way, so that the rest of the world, or rather the India, the students and the faculty members, they can use such open access resources for their legal research. And another is the open educational resources useful for education and research in ICT. This is for the science, social science, and I must say the rest of the world, and the students can access all the resources available free of cost with the help of these websites. So this one book is also there. We have coined all such resources. We have explained whatever available with us in this book. So I have also given the link in it, or rather you can, if you just want to do Google, you can type the public digital estate and internet archive. You will get the access of this book from the archive. We have uploaded this book in the public open domain for the benefit of the legal community. So I think I have not crossed my time, and I thank you very much for the patience of all of you, because I know this is the very tough time. This is the lunch time, and this is and it is very tough to listen when you are you are empty stomach. So now I hand over the session to the host.
Yes, sir. Thank you very much for such an informative session, sir. Firstly, these concepts were very new for most of us, like Boolean searching, proximity operators, JSTOR, even Lexis Advanced, Joule, code databases, but you have made it all clear by giving various examples. Personally, I was known to only Indian commercial databases like Manupatra, SCC, but today I got to know various other international commercial databases as well. It was indeed a great session, sir. Thank you so much. Now we have reached to the end of the session. With the permission of all the dignitaries, I would like to sum up with it. Respected principal, sir, should I proceed ahead?
Okay, go ahead.
Yes, sir. Thank you. I express my gratitude on behalf of MLG Society to our respected resource person, Dr. Akash Singh, sir, for sparing his valuable time for us. Sincere thanks, sir. It was a privilege to have you today. Lastly, I would like to thank our principal, Dr. C.M. Rao, sir, our vice principal, More, sir, for organizing this workshop for us, our IQAC coordinator, Dr. Aparna Kotapalle, ma'am, for constantly supporting us, Dr. Anju Singh, ma'am, for welcoming the guest, all the teaching and non-teaching staffs and the participants. Here, the third session comes to an end. Now, I would like to welcome Ms. Chaitrali to proceed with the last session of the workshop. Ms. Chaitrali, over to you.
Thank you, Shreya. Can I say one more word? Thank you very much, Rao sir, for inviting me, and I also thanks to Professor Jeet Singh Man sir for recommending my name for the session. Thank you very much. Thank you.
Thank you, sir. Thank you.
Thank you, Akash, for a wonderful deliberation.
Thank you, sir.
Aishwarya, could you please confirm if I'm audible or not?
Your voice is breaking, Chaitrali.
Aparna, ma'am? Okay. Is it audible? Is it now clearly audible?
Yes.
Audible. Is it okay now? Is it okay now?
Go ahead. Okay, go ahead.
Okay. Thank you so much, sir. Thank you, Aishwarya. Yes, sir. Good afternoon, everyone. LLB first year on behalf of Manikchand Pahade Law College. Welcome you all for session 4 of one-day online capacity building workshop on research methodology. Topic for this session is writing of research project proposal and report. For this, we are honored to have with us Dr. Jeet Singh Man sir, who is Associate Professor at National Law University, Delhi. Before introducing our respected resource speaker, I would request Professor Abhay Zadav sir to give welcome address. Abhay sir.
Thank you. Am I audible, Chaitanya? Am I audible?
Yes, yes.
Abhay sir.
Thank you. Okay. Good afternoon to one and all.
Over to you.
Now we have reached to the concluding session, that is last
Yes,
session
sir.
of this one-day workshop. The title of this
Yes,
is Writing
sir.
of Research Project Proposal and Report. So we have with us Dr. Jeet Singh Man sir. First of all, we MLNG Society, on behalf of MLNG Society's Manik Chand Pahade Law College, we warmly welcome you, sir. At the same time, we also welcome all the participants who joined this workshop throughout the various parts of this territory of India. And all the participants, we warmly welcome you all. So we have with us Dr. Jeet Singh Man sir, who would be guiding all of us on the topic of writing of research project, proposal and report. So without wasting, I know the fact that you all are eager to listen him. So without wasting our time, once again, we warmly welcome you, sir, on behalf of this MLNG Society's Manik Chand Pahade Law College. Over to you,
Professor. Thank
Chaitanya. Over to you.
I think other things are not relevant. Let us start the session. Very good afternoon, friends. Respected CM Rao, I'm grateful to you for giving this opportunity to interact with us, the participants, the teachers, and the students of research methodology. So, friends, I'm a teacher, and I think this is my introduction. I'm a student of research methodology. And let us have some interaction and discussion on.
I would briefly.
I think let me.
Jeet sir, if
Go ahead, sir.
Respected. Chaitanya, hello.
Can you proceed now? I think.
Go ahead, sir.
Yes, sir.
Okay.
Yes, sir. You proceed.
Thank you. I think we can skip that part. Let us reserve 45 minutes for this lecture and discussion, and 15 minutes for question answers. Would it be fine?
Okay, sir. Sure. Yes, sir. It would be fine. Thank you.
Okay, thank you. Again, friends, very good afternoon. I'm J.S. Man. I'm a student of research methodology, labor law, and administrative law. I strongly believe in contribution. The contribution of a person is very important. Designation is not so important, right? Because it's recognized because of his contribution, quality of research.
Answer, you are out of the.
Sir,
link.
you are not audible.
No, his link is gone. Answer. Wait a moment.
Dear participants, please have some patience. Maybe there is some network issue and sir would be joining soon.
Sir, your link gone. Everything missing. Please join again. You join again. Okay. Sorry, joining again. Please wait for a moment. Sir, you are now visible.
Is it okay, sir?
Okay.
Yes,
Now.
it's okay, sir. Now you can.
Okay. Now using hotspots. Right. I think there are certain things which are beyond our control, especially this IT connectivity. Okay, right. Yeah. So I was talking about formulation of quality research proposal, that you must contribute to the existing pool of knowledge. This is expected in case of research proposal. You must also contribute to policy changes. You should also promote larger public interest. The other things are not so relevant. Learning will happen if you come out with quality research proposal. And quality research proposal would also be accepted by the funding agency. And if you are going to repeat existing literature, formulating some research proposal on outdated topic, then such research proposal is to be appreciated by stakeholders or peer group. So friends, before that, understand that why do you require a
Your voice is breaking. Your voice is breaking continuously.
Law. And try to integrate. And while some proposal
Either problem, other problem.
I think again some network problem. Is it okay now?
Now it's okay, sir.
Can you hear me?
Yes, now we can hear you, sir.
Sir,
I
please.
think there's no problem from this side.
No. You.
Is it okay now?
Your video off
Okay.
करके आप करो.
So friends, yeah. Right. Thank you.
You stop your video, then it will work properly. Stop your video. Only sharing the particular slides.
Okay, I'll try it. Might be some problem. Just a minute. How to?
Go ahead.
It again, I think. Just a minute.
Now it is coming properly. Go
Is
ahead.
it okay now?
Yes, sir.
Okay,
It's
right.
okay.
Yes, sir, we can hear you.
Thank you, sir. Thank you. And sorry for the inconvenience. Okay, right. So friends, whenever you formulate some research proposal, the research proposal must focus on the integration between law and social science. We understand why do we require law? We require law to regulate society. And law cannot be studied or examined in isolation. If you want to do some research, maybe on dowry, maybe on any other dimension, maybe the impact of terms and conditions of employment of law teachers on quality of research, or any other specific issue. So that this research problem must integrate law and social science, because we cannot examine law. We cannot examine true character of law without understanding social science. There is a great demand for that interaction. So whenever you formulate research proposal, kindly have that interaction. Your research question must focus on some specific issue related to social science. And again, there is a confusion with respect to basic concepts like primary data and secondary data. I have examined so many books, especially written by law professors. There is a confusion regarding this classification between primary data and secondary data. So whenever you draft a research design for research proposal, kindly classify, kindly specify whether the research would look into qualitative data or quantitative data, or would look into a qualitative research approach or quantitative research approach. And for that purpose, we have to understand the fundamentals regulating primary data and secondary data. Most of us are under the impression that a statute enacted by the legislature or a judgment delivered by the Supreme Court or High Court would be covered under primary data. This is not true, because we don't understand this classification between primary data and secondary data. See, the moment you create a data, it becomes primary data. And there are so many tools of creation of primary data. And the moment you use the data that has been created by somebody else, such data would be treated as secondary data or second-hand data. So that understanding must be reflected in your research design, whether you are going to conduct empirical research or the research would be focusing only on secondary or doctoral research. And this compartmentalization, again, we have that confusion with respect to teaching and research. We feel that teaching is very different from research. Friends, teaching is an integral part of research. So is the case of research. You cannot improve the quality of teaching without research, and this quality of research without teaching. We do research. So whenever you draft a research proposal, kindly look into the dimensions of research literature, research question, research hypothesis, rank of research, right? You can examine that report on empirical research on legal aid councils. You can examine the scheme also. So research proposal is also drafted in similar manner. But research proposal must deal with unique research problem, unique research questions. If you are going to repeat that, the existing literature, nobody is going to appreciate such kind of research proposal. So I think these basics of research are very, very pertinent for drafting research proposal. See, number one, I'm going to deal with fundamentals of life, and these are very pertinent. The number one, hard work rewards. The moment you frame quality research proposal, that research proposal would be respected irrespective of your designation. The research institutions do not look into your designation, whether you're assistant professor, associate professor, or maybe vice chancellor. They always look into your contribution, your research contribution, whether you are capable, whether you are competent, whether you are committed to fulfill that requirement, to execute that research proposal. So hard work never waste. So don't believe in shortcuts. Don't try to influence the agency through other means, like you try to speak to someone, some senior professor, and the senior professor would try to influence the funding agency or otherwise. No, I think that will not really promote your interest, and that is not likely to support your causes in the long term. So don't believe in shortcuts. Hard work combined with a quality research proposal. That research proposal would be appreciated. I've seen it in various instances. When I was a assistant professor, when I got this UGC research award, it's only on the basis of that quality research proposal. There are other people also, and it can be done by anyone. JS Maan is not so special. Number two, you must think as an independent professional. You must be in a position to use your own discretion. Don't borrow things from here and there and formulate a research proposal. You must have independent discretion. You must be competent to formulate a research proposal. You must be an expert in case of your subject matter. right? Don't borrow it from others. Next, you can progress at your own by your hard work. You can never progress by borrowing things from others. You can progress at your efforts. You can never progress by pulling down somebody. And don't blame others for your failures. If your research proposal is not selected, not considered for next stage, then don't blame the agency. That agency has not taken into consideration my merits. It is that you must introspect yourself. You must acknowledge your limitations. Then revise your research proposal, submit a research proposal again, maybe to different agency. So appreciation for quality is always there, but you must live up to the expectations of that of the profession. You must integrate social science and law. You must integrate education and research, and ethical values are very, very important whenever you formulate some research proposal. Your honesty and integrity must be reflected through research proposals. Research proposals must not be a form of CCP, copy, cut and paste, right? It must be a reflection of your original idea, your competency, your devotion and commitment. So these fundamentals are very, very important when you draft any research proposal, when you formulate any research proposal. And friends, research proposal deals with research question. If that is the case, what constitutes research? Research is not a repetition of data, existing data. It's not a compilation of data. A research requires value addition. A research requires expansion of existing pool of knowledge. If a research proposal has taken into consideration that originality of research question, new dimensions of research questions, or the specific research, then there is a possibility of getting recognition of that research proposal. There must be an integration between law and social science, because we require law to regulate the society. If society is behaving in an orderly manner, we don't require law at all. See the case of Bhutan. Bhutan has not implemented RTI Act till date. The system is functioning nicely. So therefore, they don't require RTI, because RTI has been treated as a tool of combating corruption, promoting good governance. But in Bhutan and other countries, things have been recognized. The system of governance has recognized RTI as an integral part of society. So therefore, see the world ranking of Bhutan. But in India or other countries, we have implemented RTI. But we are not in a position to stimulate the quality of governance in any case. So according to John Austin, we require sanction to enforce the compliance of law. And this is again a reflection of the society's behavior, society's conduct. So you must formulate some research proposal to examine some issues affecting society at large, like dowry system. We have so many laws regulating dowry, prohibiting dowry, but what's happening in real practice? So do that kind of research where society's interests can be promoted. 1 year LLM, 1 year LLM, how this 1 year LLM was introduced. And we did not examine impact analysis before introduction is 1 year LLM. We have simply borrowed it from other countries. So do that kind of research. How come this 1 year LLM has really contributed or advanced the causes of legal research in India? 1 year LLM has become fast food degree. No time for research, right? And there is no specialization at all. So if you want to do research, this 1 year LLM is a wonderful idea. Examine the implications, examine the course contents, formulate some research proposal, or maybe PhD also. The PhD course, especially that refresher course, how the refresher course is being managed or regulated by various institutions. And that again, you must take into consideration the interest of the researcher. Researcher must know each and everything about the research proposal, the research questions and hypothesis. But the researcher must not be biased. There are so many researches. Reports are available in the public domain where the researchers were biased. They want to stimulate and propagate a specific theory, specific principle. So therefore, research was carried out. The research must be objective. Research must not be biased research. It has happened in various reports. The Law Commission report on death penalty. And the research report, Law Commission's report with respect to the specific issue has critically examined statutory provisions on death penalty. And according to the Law Commission's report, what is important? Since that 145 countries or 150 countries have abolished death penalty, therefore India should also abolish death penalty. They have not given any justification as to why death penalty should be abolished. The rationale. There are other researches also. I don't want to look into other aspects of all the research projects, but a researcher must be objective. Let the data collected by the researcher speak for itself. A researcher should not become party to that research proposal, right? This is again a very important part of report writing. There must be an integration of methodology. Understanding research methodology is very, very important. And research proposal provides for a specific process, a specific scheme. You cannot dilute that. You cannot deviate from that. And research proposal should not be a compilation of data or some essay writing or storytelling. Research proposal must be very pertinent. You must give the justification as to why the research is required to be executed and how the research will be executed. It deals with research design. So research design is very, very important part of research proposal. And I tell you, there are so many cases decided of Supreme Court whether no research was carried out. See, in one particular case, this case was decided of Supreme Court in 2019, January 2019. This is Birla Institute of Technology versus State of Jharkhand. The judgment was delivered by Justice Tapre in January 2019. The judgment deals with entitlement of teachers under Gratuity, Payment of Gratuity Act 1972. Now the judgment did not look into the Payment of Gratuity Act, that Amendment Act 2009. Now this 2009 Amendment Act has been applied from retrospective date 1997. Now this particular fact was not brought before the Supreme Court. And there was huge criticism of this particular judgment. The Supreme Court has relied upon a judgment of 1996 at Haryana Unrecognized School Association, where judgment was related to minimum wages. The judgment also relied upon the judgment of A. Sundarambal 1988. The judgment was related to Industrial Disputes Act 1947. And none of these judgments was related to payment of gratuity. But Supreme Court still relied upon these judgments and came to the conclusion that teachers are not entitled to payment of gratuity because they were not treated employees. But friends, Supreme Court ignored, and this particular fact was also ignored by advocates because they did not carry out quality research. They were not aware of the latest development regarding Payment of Gratuity Amendment Act 2009. So a researcher, whenever research proposal is submitted, research proposal must include latest data. Don't go by the statements made by various professors or scholars. You must be in a position to verify the data which is available on the internet. Don't simply copy the data from internet when you formulate research proposal, because you have some misconceptions regarding the primary data, secondary data, qualitative data, and quantitative research approach. You verify data, collect data from authentic source, original source. Then you formulate research proposal. Research proposal must be in a position to add to the existing pool of knowledge. Otherwise, what is the purpose of repeating the existing literature? If you come out with new dimensions of research, then research proposal will certainly be acknowledged by the funding agency. I have seen it in various cases. Now, fundamentals of research, friends, this is very, very important. Whenever you draft a research proposal, kindly take into consideration the fundamentals of research. Number one, identification of a research problem, a specific problem, pointed research question. You cannot generalize your research questions. It must be very specific, like impact of terms and conditions of employment of law teachers on quality research or research publications. Number two, impact of commitment and competency of legal aid councils on quality of legal aid services. Right? So you must be very specific about your research questions, research problems. And for that purpose, you must have a thorough understanding, a sound understanding of subject matter. You must know each and everything regarding the research problem. And for that purpose, review of literature becomes very, very pertinent, very, very important. So you must come out with specific research questions, specific research issues. Number two, analysis of the identified problems. You must critically examine the research problems. See, in case of a person who is ailing some sickness, the person is expected to visit a doctor. Now thereafter, doctor would advise him to go for some investigation, maybe blood investigation or other investigation. And thereafter, the doctor would come to some conclusion whether person is suffering from COVID or malaria or maybe other illnesses. Similarly, whenever you identify some problem, kindly do extensive analysis. Kindly carry out some investigations, maybe pilot study. Kindly highlight the limitations, the difficulties, the critical issues, and examine all these issues. Right? Critical analysis is very, very important, and that would also be reflected by your review of literature in the research proposal. And number three, findings and recommendations. The research proposal must propose the utility, the contribution, the rationale, and how come the research is expected to expand social interest, contribute to policy making, policy changes, and give proper justification for each and every argument when you prepare your research proposal. Don't make general statement. Be specific. Support your arguments with decided cases or the research reports executed or confined to earlier researches. So you must be very specific to the point, and you must justify your arguments when you formulate research proposal. So these are three fundamentals of research: identification, analysis, and viable solution of the problems proposed by you, identified by you. Right? Don't simply say that this practice or this specific scheme is being practiced or implemented in so and so country, so therefore India should also implement that. Certainly not. You must look into the requirements, the scenario prevailing in India, like death penalty. Since 145 countries have abolished death penalty, so therefore India should also abolish death penalty. Certainly not. Give your justification for each and every problem identified by you, or research questions identified by you. Right? So always look into that aspect. Now, yeah. Now, why do we require research, friends? This is again very pertinent. While formulating research proposal, why do we do research? Do we do research only for PhD or API or otherwise? See, we do research to expand existing theory, existing principle, existing rule. Number one. Number two, we do research to challenge existing theory, existing principle, existing rule. Number three, we do research to come out with the new dimensions of law, of theory or principle. Right? Like in case of expansion, we examine the existing theory, existing principle, we add something to that specific principle. Like in case of API, you know what was the scheme before and what is the scheme now? Regulating API, regulating journal by the UGC. So many reforms in legal education have been introduced. So the research must expand the existing pool of knowledge. Expansion is always required. So your research must expand the existing principle, existing theory, and existing law. Number two, existing theory. You must challenge existing theory. Like, legal aid services. According to Supreme Court judgments, and there are so many articles which are available in public domain, the legal aid services are wonderful. These are part of fundamental rights or legal rights under CRPC or maybe CPC, or have been recognized by the Legal Services Authorities Act 1987. But friends, what is happening in practice? I have conducted some empirical researches in Delhi and in India. And it is evident from these researches that people opt for legal aid services as a last resort. They do it under compulsion. And this is because of commitment and competency of various stakeholders. So I am challenging the existing theory that legal aid services are not living up to the expectations. And see, a 1-year LLM, according to various professors, 1-year LLM is wonderful. It has really contributed to the advancement of legal education research in India. But friends, borrowing things from here and there without applying our discretion, without applying our brain, is of no use. I have done some research on contents of LLM course. Then the quality of research projects which are being produced or have been produced by scholars, and the availability of time to do research. And I've come to the conclusion that this 1-year LLM has really diluted this specialization. LLMs is supposed to be specialized degree, but it has not. Sorry, just a minute. So if you have logical arguments, you have logical data that support your argument, that judgments also. So you can also challenge the existing theory. So your research proposal can challenge the existing theory. You can formulate some research proposal on unjust westernization of Indian legal education, or 1-year LLM, or maybe legal aid, or maybe other issues regarding empirical researches. And then you create your own principle, own theory. Now we talk about integrated PhD nowadays. Integrated PhD is being followed by the system of such degree is being followed by science departments, IITs, other specialized institutions. But nowadays we talk about integrated PhD in law, LLM and PhD, because this is required, especially for teaching profession. Internship for teachers, especially those teachers who are teaching procedural courses. We also talk about single independent regulator for legal education, etc., etc. Right? So you should come out with a new theory. When you talk about research, your research proposal should talk about new dimensions. Right? You should not be confined to mere repetition of existing information, existing data. The data collected from internet, which is highly unreliable. Don't trust internet data unless it is verified from various sources. Provide proper citation, proper details. So research proposal must focus on 3 justifications for doing research. Okay, now there is a research scheme, and this research scheme is generally followed by most of the funding agencies, whether ICSSR, UGC, Department of Law and Justice, or the National Human Rights Commission, or NCW, or any other institution. The scheme is very simple. Review literature, research problem, hypothesis, objectives. And this is not the time to discuss all these components. I expect you know basic ideas about these, the fundamentals of research methodology. Review of literature, research problem, hypothesis, and review of literature is the starting point of any research proposal. It is the originator of any research problem or research question. extensive review of literature is required. What is review of literature? Why review literature and how review literature is done? I think these are very, very important when you draft and research proposal. Now, thereafter, you have a rationale, give rationale. Then operational concept is very important. When you do research on a specific aspect, maybe legal aid, or maybe this 1-year LLM, you must define the term, specific terms. Operational concepts are very important. Suppose you do some research on child marriage, child labor. So you must define the term child. Who is a child? Because child for contract law would be different from employment law or other parameters. Child for RTI Act is very different. So you must provide a specific definition of operational concepts. Rationale of research. What is the utility? What is the significance? And thereafter, research design is very, very important. Research design deals with execution of research questions, right? Research questions, your competency, your research universe, research methods, tools for data collection, right? Analysis of data, and finally, finding and recommendations. You can also apply these steps when you write your research report or proposal or write research papers also, right? Now, let us have some discussion on how to formulate a quality research proposal. So what is a research proposal? Why research proposal? And how to formulate some research proposal, where to submit. See friends, research proposal is a plan, is a proposed plan to execute some research, where you come out with your research questions, your research plan, your execution, your universe, and thereafter you submit it to the appropriate agency. You formulate some research proposal for PhD also. That is for different requirement. There you are not required to provide a budget estimate. So research proposal for PhD is different from research proposal submitted to some funding agencies like ICSSR, UGC, etc., etc. So before drafting any research proposal, kindly strictly examine the terms and conditions for formulating research proposals, like eligibility criteria, whether assistant professor is eligible or associate professor is eligible, and then what is the research experience that is required. Most of the agencies would look into your research publications, your research competency, whether you are competent to execute that research proposal or not. And nature and scope of subject matter is again very, very much relevant. If you come out with empirical research, there is a great demand for empirical research. Great demand. Otherwise, if you are going to submit some doctoral research, then it is unlikely to be accepted by the funding agency or maybe that PhD the committee, right? So contents are very, very important. Contents are also identical, but it all depends upon the funding agency. In some case, you would find research question at first place, thereafter research review of literature, etc., etc. In some of the cases, you would find review of literature, thereafter a research question, hypothesis, etc., etc. It all depends upon the funding agency. So you must follow meticulously the research, the scheme, the research proposal, or that specific document providing components of research proposal. You must be very sure about execution of the research, how the research would be executed. If you are not in a position to justify that execution, research proposal would not be recognized. And nowadays, online research proposals are invited and proposals are screened solely on the basis of requirements of the funding agencies and the quality of research proposal. Then research proposals are shortlisted. Thereafter, researchers are invited for making presentations. Thereafter, final approval is done by most of the funding agencies. And friends, research methodology is very, very important. Research steps, research plans, very, very important for drafting research proposals. So whenever you draft research proposals, you must come out with a scheme, with a time frame to complete the research, right? You must be very sure about the specific deliverables which are expected by the funding agency, like review of literature requires 1 month, framing of questionnaires 1 month, pilot study 1 month. So you must come out with time framework for completion of the research assignment. Report writing, that you may include some elements of seminar, workshop, data analysis, report writing, etc., etc. Right? Then thereafter, budget estimate. This is very, very important. But budget estimate. What would be the component of budget estimate? Now here, it all depends upon your research proposal and duration of that specific research assignment which is expected to be executed by you. You must include some elements of human resource, whether you require 1 research associate or 1 research assistant. What would be the honorarium? See, generally honorarium is decided by the funding agency, whether it will be 30,000, 25,000 or maybe 50,000 rupees. So you should follow that specific policy of the funding agency. Human resource. Thereafter, honorarium for project director. This is hardly seen in case of government researches, but it has been permitted by Department of Law and Justice. I am doing 2 different projects, empirical research projects for Department of Law and Justice, where there is a component of honorarium for project director. 15,000 rupees has been allocated for the purpose. Otherwise, you don't find this component in case of research proposals for UGC, ICSSR, NCW, or maybe Human Rights Commission, etc., etc. This is not available because they are under the impression that the research director would get that honorarium from the respective institution, would get the salary from the specific institution. So there is no need to pay him for the research, specific research. Then thereafter, field study. If you are going to conduct empirical research, then you can allocate specific amount, specific budget for that field study. In case of non-empirical research, you can have that component. It all depends upon you, right? You can conduct seminars also. You can include that element of seminar. Then thereafter, printing of questionnaires, material report writing, and you can include the specific honorarium for data recording like SPSS, etc., etc. Then you can engage someone to take care of data recording, because most of the law professors, law teachers are not very familiar with the data recording, data analysis, data display. So you include some component of data recording and report writing, right? Now, friends, whenever you write research proposal, I'm talking about requirements of a quality research proposal, you must justify all the components. All the components are required to be drafted neatly. There should not be any ambiguity. Your research review of literature must be connected with research questions, hypothesis, research design. So there must be a connection, there must be a link between various concepts. If your research design is very different from your research problems, then it would create problem for you. You won't be in a position to justify that. So focus only on contemporary issues, issues which are socially relevant, issues which have affected society, issues which are likely to contribute to larger public interest, issues which are likely to contribute to policy changes. So I think these issues are always taken into consideration for award of any research project. And again, I'm reiterating it, recapitulating it, friends. There is a great demand for empirical research, great demand, and there is no supply. If you submit some research proposal dealing with empirical research, there is every possibility of getting approval or acceptance from the funding agency, right? So focus only on specific issues. A research proposal must be very unique, and you must have seen that that report on legal aid councils and the research proposal dealing with the legal aid councils. You can examine all the components. See, no one is perfect. I'm also not perfect. I know my limitations, right? So you must learn from your limitations. learn from other best practices, and try to improve upon the research proposals which are available in the public domain. So as a law student, as a student of research methodology, contribute to the existing pool of knowledge. Now these are the funding agencies, ICSSR, major and minor projects, special projects are also available. 40 lakh rupees, 70 lakh rupees, UGC, NHRC, Department of Law and Justice, Women and Child Development, the Ministry. So you have so many funding agencies. You have international agencies also. Right now I'm doing some project for Spark. This is international project, 70 lakh rupees. And we are collaborating with the Chinese Law School, the Beijing University. And we are working on best practices regulating legal education research. So friends, there are a lot of opportunities which are available for quality research proposals. I'm always available to support your endeavors, to help you to draft any research proposal, especially empirical research proposals. Right? I think that's it from my side. And let us have some interaction and discussion regarding drafting of research proposal, submission of research proposal, and difficulties faced by various scholars when they draft research proposal, especially funding part. Yeah, that's it, friends. Now let us have some interaction and discussion. Thank you very much, Professor Rao, again for giving this opportunity and interacting with all the stakeholders of legal education and legal research. And because of paucity of time, we can't discuss each and everything which is related to the fundamentals of research methodology. Over to you, sir.
I could see only one question in chat box. With your permission, I would read
Just
it
a
out.
minute. Let me.
So may I? Okay.
Just a minute. How to stop sharing? Sharing, okay. No, I think there's a problem. Yeah, go ahead.
So the question is how to make a research report. I think you have, that was
How to make research report. So kindly examine that the copy of report. Have you circulated the copy of my research report on legal aid councils to all the participants?
Sorry, sir, could you repeat?
Have you circulated the copy of that
Not hearing.
empirical research report to all the participants or not?
No. Yes, sir. Yes, sir.
It has been circulated on their WhatsApp group on which they have joined. Please go through it, participants.
Okay. See, number one, friends, you must understand the requirements of research report, right? You won't get that scheme, especially with most of the funding agencies. So you must understand, number one, you can classify chapters according to your requirements. Number one chapter to deal with introduction of research. Number two, theoretical perspective. Number three, that empirical research dimensions. If you have carried out some empirical research, then focus only on the data collection, research design, sample, that research sampling, the techniques, and then examine the data according to that. Tabulation, histogram, it all depends upon the specific topic. Thereafter, you must have a specific topic on findings. This is very specific chapter on findings. This is very, very important. And you must be very specific when you write findings. It must be systematic. All the findings must be supported by data, maybe primary data or secondary data, and then give proper justification for findings. And findings must be related to the issues identified by you, issues highlighted by you. Right? Thereafter, the next chapter, the final chapter would be your recommendations, your suggestions to overcome the issues identified by you. Then bibliography, etc., etc. Right? So it is not so technical to draft any research report, but you must know the components. If there is a specific document and the document provides for the components of research report, you are required to follow that component. Otherwise, you can devise your own mechanism. But the research report must provide all the details of your research, empirical research or doctoral research, as the case may be. Yeah. Anything
Sir,
else?
there is one more question. Are there research grants available for colleges or not coming under UGC 2F12B?
Yes, yes. I think in most of the cases you would find that certain research projects are only available to public institutions, not available to private institutions. But as far as this ICSSR, and there are other institutions also where teachers from private colleges or private institutions, where these institutions are recognized by UGC under that provisions, yes, they are also eligible to submit their research proposals. So for that purpose, you have to see the notification whether teachers from private institutions are eligible or are not eligible. Right? In case there is no specific mentioning that over there, you can clarify that. Otherwise, most of the research proposals involve teachers from public institutions like Department of Law and Justice. They're engaging only the teachers from law universities or specific NGOs. They invite proposals from specific institutions, and these proposals are not available in the public domain. See, ICSSR, everything is available in the public domain. Whether maybe minor project, major project, all the details are available in the public domain. But there are some essential requirements, like person must be from this institution where that institution has been recognized by the UGC. Now they do it only for the purpose of assurance that that institution would carry out the specific research. It is a kind of the recognition given to the institution, because in case of private institutions, where the project is not carried out or there's some funding issues, right? Because of these constraints, they hardly engage private institutions. Otherwise, you have to examine the notification issued by the specific agency inviting research proposals. Yeah.
So there are
Anything
no
else?
as in particular questions.
Okay, right.
So
right.
with your permission, we would conclude. Yes, sir.
Right. I think these are my contact details. Don't use the cell phone. If you have any specific query, you can mail it to me. Right? jsman@nldelhi.ac.in.
Okay.
Right.
Thank you so much, sir.
Okay.
With
Thank you
your
very much.
permission, we
Take
would
care.
we would move to concluding part of our session. Okay. Before moving to concluding part, I request everyone to check the feedback link as sent in chat box. And summing up today's session, I would like to thank Dr. Jeet Singh Man sir for teaching techniques of writing of research methodology. Indeed, many of us would use the skill sets in their career as well. I would like to thank our principal, CM Rao sir, Vice Principal SN More sir, IQAC Coordinator Dr. Aparna Kotapalli ma'am for their constant support and making organize this successful event. I would like to thank Abhay Jadhav sir for giving welcome address. I would like to thank Management Committee of MP Law, teaching and non-teaching staff, technical team for today's event, and last but not the least, all the attendees for that patient listening. Now, with the permission of dignitaries, I hereby declare that one-day online capacity building workshop on research methodology is successfully completed. Thank you so much, Dr. Jeet sir, for joining us. Thank you, everyone.
Man sir, thank you very much.
Thank you, sir.
Man
Thank
sir,
you.
thank you very
Thank
much.
you. Thank
Man
you.
Thank you
sir,
very much for joining us.
Participants are requesting for your PowerPoint presentation to be shared. Can it be done?
No problem. Nothing so secret. Of course, I'm always available to stimulate research culture in India. If they require
Thank you.
PPT, no problem. I don't mind.
Okay, sir. Okay, thank you.
Okay, thank you, sir.
Thank you so
Thank you.
much,
Bye.
sir.
Bye.
Thank you, Mitch. ప్రసాద్ కెమెరా ఆఫ్ చేయరా బాబు పద్దాక చూస్తున్నావు నేను